People against Richard J. Godfrey, 25F244515. Come up to the podium. Krista Cole, have a seat at the table. Harley Wykosh, have a seat at the table. Come on up to the podium, sir.
Good morning, Your Honor.
Your name? Your name?
Richard J. Godfrey.
All right. You haven't been drinking this morning, have you?
I'm sorry?
You haven't been drinking this morning, have you?
No, sir.
So if I give you a PBT right now, it's going to come up clean?
Yes.
We're going to just double check that. Have a seat right there. I'm going to have them give you a PBT, okay?
Put it right here.
First row. Krista Cole. Come on up to the podium. Krista Lee Cole, 25F244368 A and B. Your name?
Krista Lee Cole.
You're charged with driving on a suspended, ma'am, and you also have a second charge of disobey a traffic control device. You have the right to a lawyer. I'd be happy to give you one at public expense if you would like one. Would you like a lawyer?
No, thank you.
Okay, so I'll go ahead and arraign you and we'll go from there, all right?
Okay.
It is alleged that on July the 12th of 25 that you're operating a motor vehicle in Breland or Hall in Flat Rock, and that you did disobey a traffic control device, a construction zone sign, count one, that's a 2 points total infraction. You also have driving on a suspended, which is punishable by up to 500 fines, 93 days jail costs, or all of those in 2 points. Do you understand that?
Yes, Your Honor.
I don't give you a PBT. Did you sign the advice? Yep. Did you sign the advice of rights
Yes, Your
to
Honor.
read it?
Yes.
Did you understand it?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
Okay. You still wish to waive your right to a lawyer?
Yes, Your Honor.
I'm going to enter a not guilty plea for you. I'm going to give you a $500 personal bond. You do not have to post any money. I'm going to send you to the prosecutor. You can talk to the Flat Rock City Attorney. And then either way, you're coming back in front of me. You cannot leave the state without consent. You can't violate a law. You must appear in court as directed. Those are the bond conditions, okay? Do you understand all that?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Are you employed?
I work 4 days out of the month,
What is that? Doing what?
waitressing.
Okay. All right. So you go out, we'll set you up. Either way, you'll come back in front of me. And if they don't give you what you want, you tell me, I'll give you a lawyer. Okay?
Okay, thank
Good
you.
luck. Harley Quinn Wykosh, file number 25F244090. Your name, ma'am.
Harley, welcome.
You're charged with disturb the peace. You have the right to a lawyer. Be happy to give you one at public expense if you would like one. Would you like one?
No,
I'll go ahead and arraign you on July 11 of 25. It is alleged that you were in the city of Flat Rock, County of Wayne, on Walnut Creek Drive at or near 28521 Walnut Creek Drive in Flat Rock, and that you did disturb the peace. That is a misdemeanor punishable by up to $500 in fines, 90 days jail costs, or all those. Do you understand that?
yes, sir.
Did you sign the advice of rights and read and understand it?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
Do you still wish to waive your right to a lawyer?
Yes.
I'm going to enter a not guilty plea, $500 personal bond, okay? You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm going to let you go talk to the city attorney, see if you can work something out. If you can, great. If you can't, then I don't know what.
Where am I going? I'm sorry.
You're going to go right out in the hallway,
Okay.
and he's going to take you to the city attorney, okay?
Okay, thank you.
You're welcome. Eves, Christina Eves. 20B138279C, 20B138279A. Good morning, ma'am. Your name?
Christina, yes.
All right, so you have the right to a lawyer here today. You owe $5 on one case. And you owe.
Okay, go ahead.
You you owe 175 on the other. Is that what these are up for, Lisa? Show cause hearings on each of these?
Yes, show cause for non-payment.
All right. Do you have the money?
Not today.
How much do you have today?
Maybe.
Okay. Here's what I'm gonna do. Where do you work at, ma'am?
I work in Belleville at the company called Temperament.
I'm gonna waive the balance on, the $5 balance on 2OB138279A. You owe $175 on the other file. You pay $50 now. When can you pay the rest?
3 months,
3 months.
like $50 a month.
How much do you make in your employment?
How much, I make $18 an
How
hour,
many hours do you work?
40.
You're asking for a lot. Are you married, kids,
Yes,
both?
yes,
Does your husband work?
yes.
Why?
We have bills and we're behind right now, we're trying to catch up.
You gotta come talk to me. Right? This has been going on since March of 24 when I sentenced you. You were supposed to pay it that day. I don't know why it wasn't paid that day. I'm gonna assume I addressed it subsequent to that date. You're asking for a lot. I mean, I don't mind working with you, but come on. You pay $20 bi-weekly. I'll do that. When do you get paid next?
Next week,
All right, you pay $20 bi-weekly beginning August the 18th. Do you think you can do that?
yes,
Now, if you don't have the money, you have to come talk to me. Call the court, we'll go on Zoom, okay?
okay,
Or else come in here on or before your due date. So go down and pay the $50 on the one and you're all set. Good luck. People against Godfrey. Let's find out, John.
I gave you a sticky note there.
Richard J. Godfrey, 25F2444515. Okay, so you registered zeros. Good. Your name?
Yes,
Your name?
Richard J. Godfrey.
You're charged with disorderly conduct, public intoxication. You have the right to a lawyer. If you want, I will give you one now, or I will arraign you and let you go talk to the prosecutor. It's your choice. Hey, sir, come here. Come on back in here.
Oh, I'm sorry.
You're talking on the phone, right?
I was answering my attorney trying to walk out.
You got your phone into the ear. Please don't do that. Not in the courtroom. Okay.
Yep.
Thank you. So you're charged with disorderly person, public intox. This is alleged that on July 23 of 25. So I guess I need to ask you that first question. Do you want a lawyer?
No.
They think that you were publicly intoxicated July 23 of 25 at 3:04 PM on Arsenal near West Huron River Drive in the city of Flat Rock. That is a misdemeanor punishable by up to $500 in fines, 90 days jail, costs are all those. Do you understand that?
So what is the fine, $500?
These are the maximum penalties provided by law. That's what I have to tell everybody.
Okay,
I didn't say I was sentencing you to $500 in fines or 90 days jail or cost or all those. I didn't say that. Those are the possible penalties. Okay?
yes, sir,
Do you understand that?
I do.
Did you sign this advice of rights?
Did I what? I'm sorry, I'm hard of hearing.
Okay, that's all right. This advice of rights form, did you read it?
Yes, I did.
Did you understand it?
I do.
Did you sign it? You signed it, right?
This here?
The advice of rights form.
Yes,
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
yes, sir.
Now, do you want a lawyer?
No, I can't afford one.
Well, I told you I'll appoint you one if you want one. I'm gonna enter a not guilty plea for you, first of all.
Okay,
I'm gonna give you a personal bond. You don't have to post any money, okay?
yes, sir.
$500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol. no illegal drugs. You're not to purchase, possess, or consume any one of those. And that's where I'm gonna go from here. If you want a lawyer, I'll give you one. Otherwise, I'm gonna send you to the prosecutor to talk to him.
I don't know what to do, to be honest with you.
It's up to you. If you
I
want,
guess I need a lawyer.
I'll give you a lawyer, have him go talk to the prosecutor, not guilty, pleas entered, okay?
Yes, sir.
All right, good luck. We'll see you back in here either way today. You understand that, right? Yes, sir.
Okay.
Don't go anywhere today until we're done. Okay?
Okay, can I go out to my truck or?
He wants to talk to the prosecutor, Your Honor.
He wants to, we're gonna give him a defense lawyer.
Okay. Just have a seat in the hallway.
And we're gonna set you up with the lawyer that
Okay.
will then talk to the prosecutor, see if they can resolve this. Either way, whether they can or can't, you come up here back in front of me, okay?
Yes, sir.
All right, good luck. Hilario Romero Chavez, 25T718-463. Your name, detective?
Detective Sergeant Mark Driscoll, Traffic Report.
Okay, raise your right hand. You solemnly swear affirm under
Have a seat in the hallway.
Okay.
solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Go ahead.
On June 7th, 2025, at approximately 0238 hours, Trent police officers were dispatched to the area of 3rd Street and Atwood in the city of Trenton County Wing for a male asleep behind the driver's seat of the vehicle. Officer Evan McLeod arrived on scene where he observed a white 2011 Ford Fusion bearing Michigan license plate 3 Lincoln Union X-ray 52 facing south in the roadway, stopped partially in the intersection. Officer McLeod observed a male later identified as Hilario Romero Chavez, a Spanish male, date of birth of 2/28/1983, in the driver's seat sleeping. Officer McLeod observed the vehicle running with the keys in the ignition and Mr. Romero Chavez's foot on the brake pedal. Officer McLeod and Officer Erica Ducky placed the vehicle in park and awakened Mr. Romero Chavez, where they observed a Modelo beer can in the cup holder and smelled a strong odor of intoxicants emitting from Mr. Romero Chavez. Officer McLeod had Mr. Romero Chavez exit the vehicle where he observed him unsteady on his feet, having bloodshot and glassy eyes, and his speech was slurred. Mr. Romero Chavez provided his Guatemalan identification card. Officer McLeod again could smell a strong odor of intoxicant emitting from him. During Officer McLeod's questioning, Mr. Romero Chavez spoke both English and Spanish. Officer McLeod requested Mr. Romero Chavez to perform SFSTs, to which he replied no. Officer McLeod read Mr. Romero Chavez's PBT rights verbatim from the Trenton Police PBT advice of rights form, and Mr. Chavez refused and then was arrested. Officer Blake Rusnick arrived on scene and assisted with the inventory for the Trenton Police impounded vehicle policy. Officer Rusnick located a cellophane bag containing a white powdery substance on the driver's seat. Upon returning to the Trenton Police Station, Officer Rusnick tested the substance using the mobile detect multi-drug test kit, which revealed a positive indication for cocaine, and weighed the substance, which revealed 0.1 grams with packaging. Excuse me. Officer McLeod transported Mr. Romero Chavez to the Trenton Police Jail, where he read his chemical test rights verbatim from the DI-177 form, which he refused to provide a breath sample. And Officer McLeod completed the DI-93. Officer McLeod authored a search warrant for Mr. Romero Chavez's blood, which was reviewed by APA Suitman Bothell and authorized by Judge Coleman Hudson. Mr. Romero Chavez was transported to Henry Ford Hospital, Brownstown, where Art and Jennifer Finley utilized the Michigan State Police blood kit, drew 2 1cc vials from Mr. Romero Chavez's right arm. On June 9, 2025, I sent the Michigan State Police blood kit via priority mail to the Michigan State Police Forensic Lab for testing. On June 18, 2025, I received Michigan State Forensic Lab report TX25-7973, authored by forensic scientist Stephanie Grabowski, which revealed Mr. Romero Chavez's blood alcohol was 0.213. Additionally, I checked Mr. Romero Chavez's vehicle and a Michigan driver's license record through Link, which revealed he had no insurance and never obtained a license. On August 5th, 2025, I received Michigan Crime Lab report NV25-976-1, which was authored by forensic scientist Daniel Case. the lab report identified the narcotic substance as cocaine.
Based on your sworn testimony, I find the crime possession less than 25 grams of cocaine. Super drunk, OWI, and drive while suspended, revoked, denied were committed. There's probable cause to believe the crime was committed by the defendant. You must have sent this over yesterday. This is dated August the 6th. I changed in the date. We haven't done the signing on record today, August 7th. I'll initial that. I'm signing and dating the complaint and the warrant for the arrest of the defendant. Have a good day. Thank you.
Have a good day.
Paige Bondi, Paige Kathleen Holiday Bondi, 25D715-702. Good morning, Detective. Your name?
Good morning, Detective Jeff Claft, Brownstown Township Police Department.
Raise your right hand. Do you solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got?
Yes, sir.
Okay, go ahead.
On February 27th, 2025, at approximately 11:06 p.m., Officer Washburn and Officer Fox were dispatched to 19001 Telegraph Road in Brownstown. That's the BP gas station. They were dispatched for reports of a driver passed out behind the wheel of a burgundy Ford Flex. Upon arrival, Officer Fox observed the burgundy Ford Flex parked next to one of the gas pumps with the driver's side door open. Officer Fox also observed a black male, later identified as Cortez Martin, in the driver's seat slumped over the center console. The front seat passenger of the vehicle was a white female, later identified as defendant Paige Bondi. Officer Fox made contact on the passenger side, while Officer Washburn made contact with Mr. Martin on the driver's side. Officer Fox asked defendant Bondi if they were under the influence of any drugs. Defendant Bondi admitted to consuming mushrooms. Defendant Bondi's speech was mumbled, slurred, slow. Her eyelids were low and appeared heavy, and she was acting very lethargic. Officer Fox looked down near her feet and observed a glass bulb meth pipe with burnt residue inside lying on the floorboard of the car. When asked defendant Bondi if she had any drugs or pipes in the vehicle, she told Officer Fox no. When Officer Fox asked her about the meth pipe by her feet, defendant Bondi tried to place her foot over it and hide it. Officer Fox told defendant Bondi to exit the vehicle. Defendant Bondi exited the vehicle with her purse in hand. When asked if Officer Fox could make sure defendant Bondi didn't have any drugs in her purse, she told Officer Fox yes. During the consent search, Officer Fox located a loaded hypodermic needle with the cap on it. When asked if there was any heroin or methamphetamine inside it, defendant Bondi said both. As Fox continued to look through defendant Bondi's purse, Officer Fox located what appeared to be a folding card holder. Inside, Officer Fox located several pieces of suspected crack cocaine rocks. Officer Washburn placed defendant Bondi in handcuffs and placed her in the rear of the patrol car 1813. Officer Fox continued to look through the contents of the purse. He located a small clear plastic baggie with suspected heroin inside and a small blue metal vial with suspected methamphetamine inside. While searching the vehicle, due to the meth pipe being in plain view, Officer Fox observed a small colored pouch bag sitting on the dashboard directly in front of the passenger seat where defendant Bondi was seated. Upon looking inside the bag, Officer Fox located a second glass bulb meth pipe with burnt residue inside. He also located a glass stem crack pipe with chorboy and burnt residue inside, and a second loaded uncapped hypodermic needle with a red and brown liquid inside. Mr. Martin requested medical attention. Our fire department arrived on scene and transported him. Officer Washburn located a folded up gum wrapper with Mr. Martin's person. When Officer Fox unfolded the wrapper, he observed a tan brown powder substance consistent with heroin. Defendant Bondi was turned over, Mr. Martin was turned over to Brownstown Fire Department for treatment. Defendant Bondi was arrested and brought back to the Brownstown Police Department. Evidence that was collected was the suspected crack cocaine, methamphetamine. A field test was completed with positive indication. The loaded syringes were not field tested due to the hazard of testing them. The heroin recovered was also not tested. On 4/21/25, Detective Attard conveyed all controlled substances to the Michigan State Detroit lab for further testing. On May 1st, 2025, lab results from the Michigan State lab were provided. Recovered from Mr. Martin's person, it was identified as 0.3982 grams of fentanyl. Recovered from defendant Bondi's purse, it was identified as 1.0734 grams of cocaine. And recovered from defendant Bondi's purse, it was identified as 0.2747 grams of methamphetamine. Defendant Bondi shows prior convictions on February 7, 2018, assaulting, resisting, obstructing a police officer, pled guilty on 9/6/2016, obstructing by disguise, pled guilty 10/4/2016, malicious destruction of property, and 9/24.
They did not include a habitual offender notice.
Oh,
so you
okay.
don't
I'm
think
sorry, Your Honor.
those, but I'll go ahead and authorize. I'll note that you signed this yesterday. I'm changing the date of the signing on record to today, and I'm initialing it. There's probable cause to believe the crimes of possession of less than 25 grams of cocaine, possession of meth, and possession of heroin/fentanyl were committed. There's probable cause to believe those crimes were committed by the defendant. I'm signing and dating both the complaint and the warrant for the arrest of the defendant. Thanks a lot. Have a good day.
You too, sir. Thank you.
Curtis Amati. Call in Beth on this. I need Elizabeth Wilds on this. This is People Against Curtis Brent Hamadi, file number 25R513926A.
Good morning, Judge. And I'm here to turn back to Mr. Hamadi. Hamadi, state your name for the record.
So Ms. Wilds checked into this, and I'm going to let her explain this. This was all over the other convictions out of Arizona and Florida, and at least it appears as though he had the conviction out of Arizona from '99, the conviction for OWI in February of 12 out of Florida. Excuse me, but the other one from 2012 out of Arizona, we could not verify. Your name?
Elizabeth Fleischer.
So can you repeat that? Is that true? He's got 3 convictions on his precinct.
I'm sorry, Judge. It's the 99 conviction that would be substantiated.
Well, he's got 3 on here, right?
Right. It's the one from 1999 that we had an issue with. That's why it was adjourned twice already on this to verify that. And then also, Mr. Hamadi's, there is no conviction out of Florida as well, Judge.
Wait a minute. Why don't you tell me what you did?
Yes, Your Honor. Yes, we could go ahead and kind of extensively look at the record. And because of the sex registration, Florida is reporting the Arizona offenses. So he is correct. So what's occurring is on the Florida driving record, it is showing a conviction for drinking and driving, and it's also showing on the Arizona CCH. It is the same offense. That is out of Arizona, and that is the 2012. On his Michigan driving record, it is showing a conviction for the 1999 OUIF, but what catches your eye is the fact that the arrest date and the conviction date are both from, I believe it's March 19th, 1999, but it is indicating that that conviction was by default, the same as the 2012 that Mr. Hamadi admits and is also on his CCH. That also reports back at the Michigan driving record by default. So the question at hand, is the 1999 a conviction or not? I ran his Arizona driving record. I ran his Arizona CCH along with Florida, along with Michigan. I can't find it on any criminal history. I can only find it on the Michigan driving record entered as a default with, again, the same arrest and conviction date.
So in your view, how many prior convictions does he have? It's not the 99 one. He doesn't have that.
Correct. I'm seeing the 2012 out of Arizona, and then I believe this would end up being his second offense.
So not that there are two in 2012, one out of Arizona, one out of Florida. You're saying
Those are the same.
right?
Yeah.
So he's got only one prior drunk driving conviction, as far as you can tell, and that is in June of 12, correct?
That is correct, Your Honor.
Let me
That's the only
just-
one I can confirm.
Okay. Give me 1 second, please.
Sir, you gotta take your hat off.
All right, now we had a problem with the prints, by the way. I don't know what happened. This is what I read. Paramus P, defendant needs to be printed again. Called defendant and advised to get printed at Gibraltar before sentencing. Did you do that?
Yes, Your Honor.
He did, Judge. I verified before today.
All right, so do you have any questions of Ms. Wiles before I let her go? So I'm gonna count this as him having one prior OWI or impaired conviction, and that is the 2012 OWI, it appears, but not the 99 and not the other one.
Correct. Or neither is the one in Florida, Judge. That one was just
I understand. So we have one prior OWI conviction, and that's it.
correct.
Besides these others that are not drunk drivers.
Correct.
So, anything else?
Nothing further, Your Honor.
You can go ahead and go. Thank you very much.
Thank you, Your Honor.
Are there any material additions? So with that, and I'm going to strike it just for the record, I'm going to cross out the OWI, and I'll say excluded. Okay, and then, so I'm modifying the report in that aspect, and then also the the February of 12 case excluded, and I'll initial that. What, is everything else in this report accurate?
Everything else, Judge, is accurate, correct.
Is there anything you'd like to say on his behalf?
Just that Mr. Hamadi is 51 years old right now, and he owns his own home renovation company. He has a 13-year-old child who lives with him, and he just recently reconciled with his wife. They've been separated for a number of years. So he's in the process of getting his life together. If you notice the dates on a lot of those convictions, Judge, those were prior from Mr. Hamadi's past. Let's say when he was younger and not as smart as he is today. And I would let the court know that, you know, he's taken responsibility for everything that he's done. He's tried to make amends. Obviously, he's not run away from his problems. He's faced his consequences, got through it, and is trying to move on, Judge, and he has the court to take that into consideration, as well as the fact that this will be the third time that we will be before the sentencing on this case, Judge.
Anything you'd like to say?
Your Honor, just that I know that I've made a lot of mistakes, and I'm too old to be doing this, and I just want to do the right thing and move forward and take care of my family and be a positive member of the community. And I apologize to the city of Rockwood and to this court. And I just want to move forward as best way as I can, Your Honor.
Additionally, Judge, if I may, Mr. Hamadi is also taking initiative to start the Victims Impact Panel program. So he's making good faith, positive efforts towards getting a lot of the stuff that he needs completed.
You're still getting yourself into trouble. I mean,
There's no reason that I should have been driving.
yeah, but it's not just that. You had in 21, even, that's 3.5, 4 years ago, but you had a criminal trespass in Florida. You had a larceny in the second degree out of Florida. I mean, it's time to grow up.
I understand, Your Honor, and the trespassing was involving my daughter who I was living with me, and I just promise you that I didn't intend, for any of that stuff to happen. I made a lot of bad choices, and I need to make better ones. And I apologize to this court.
I believe, Judge, also the larceny charge was the fact that there was an issue between him and his daughter. He took the phone away from her. And he's getting charged with larceny.
18 months probation. You cannot leave the state without the consent of the court. I'm not sure how you're working and still collecting government assistance. You're saying you're collecting bridge card money.
Because my work has been pretty non-existent. I haven't worked too much in the past couple months.
18 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address or place of employment or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. If you consume food or other items that contains those substances, that will be deemed a violation. Submit to chemical testing, PBTs and ETGs as follows. Bi-weekly for 3 months. If you're clean, I'll make it monthly for the duration of probation. Attend AANA twice a week until you're in outpatient treatment. My court officer is going to give you a form. You have to go in person. Every time you go, you have to have that form signed. Every time you come to probation or to court, you have to bring that form with you. You have to go twice a week until you're in outpatient treatment. Once you get in outpatient treatment, you no longer have to attend AA or NA. Attend the Victims Impact Panel, which is one night put on by Mothers Against Drunk Drivers. You're to serve, he spent 1 night in jail on this, right, counsel?
I believe so, Judge.
4 days jail credit, 1, serve 3. I'll let you serve the other 3 on the court work program. There's a $35 a day charge for that for a total of $105. Pay $300 in fines, $250 costs, $75 victim's rights fee, $50 justice assessment, $675 in fines and costs, including the mandatory fees. You have $60 screening fee for $735. You have probation fees of $360, bringing your total to $1,095. They're $20 a month, and then you have cost of recovery of $225 for a total of $1,320 plus court work program fees. Your total should be $1,425. Would you double check that, man, please? If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. Do you understand that?
Yes, Your Honor.
Do you have all of this to pay? How much does he have, Mr. Gate?
Judge, he needs to pay this fine.
Does he have anything today?
I don't believe so, Judge.
I don't, Your Honor.
How much can you pay per week?
Can I do $50 or
A week?
probably swing that?
You need to get back to work.
I do.
$50 weekly beginning August the 25th. If you ever need more time, you call the court. We'll go on Zoom on or before the due date. Or you can come in and talk to me on or before the due date, 8:30. I'll be more than happy to give you an extension. Please don't ignore me, okay?
Yes, Your Honor.
You'll meet with probation before you leave. Any questions?
No, Your Honor, only that I heard you mention no marijuana. I am a medical card holder. That was the only thing.
Yes, you do have a medical marijuana card. I won't violate you because the law doesn't, well, it makes that inappropriate if you test positive, so long as you possess and provide proof to probation of a valid medical marijuana card, okay?
Yes, Your Honor.
Good luck. Thank you. Stay out of, you gotta get your life in order though. Good luck. Krista Lee Cole, 25F244-368, A and B. Ms. Cole, come on up here, ma'am, and I will take your plea. Your name?
Krista Lee Cole.
All right, so you're going to plead to allowing an unlicensed driver to drive, and then they're going to dismiss the suspend, revoke, deny. And you are going to also give a dismissal of the disobeyed traffic control device, right?
Yes, Your Honor.
Is that what you want to do?
Yes, Your Honor.
If you do that, possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand an advice of rights form here today?
I did.
If you plead guilty, you'll be giving up all those rights, and there would not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
You have the right to a lawyer. Do you still wish to waive your right to a lawyer?
Yes, ma'am.
To the charge of allowing unlicensed driver to drive, how do you plead?
Guilty.
Were you in control of a 2016 Ford that was being operated on Vreeland near Hall and Flat Rock at 7:29 PM on July the 12th of 25?
Yes, Your Honor.
And you were unlicensed, actually, you were revoked at the time, were you not?
Yes.
Anybody forced you to plead guilty?
No, Your Honor.
Are you on probation or parole?
No.
All right. You got your license back out of Ohio and then you blew the restrictions? I mean, the restricted license, is that right?
No, Your Honor. In Ohio?
Let me just check this. Did you ever live in Ohio?
No, Your Honor.
Administrative amended due to Ohio Circuit Court ruling on October 10, 19. Not consume intoxicants, no alcohol or drug related activity, may drive to and from your residence. Oh, that. Okay, I see. All right. You're going to get a valid license now, right?
Yes, Your Honor.
You got to do that though, okay?
Yes.
What else do you want to say? Anything else?
No, I'm just currently in the process of getting my license back. I have 2 kids getting ready to go to preschool and I have to get my license back. So I'm doing everything I can to get that. I'm almost there. I just have to finish a couple more things up.
All right, 100 fines, 200 costs, 75 victim's rights fee, $50 justice assessment, 4 1/4, 90 days. Again, for the record, the revoked, dismissed, and the disobeyed traffic control. Wait a minute. He's also got you pleading to impeding. My apologies. You're pleading to impeding traffic, true, and then he's dismissing the traffic control device, correct?
Gotcha.
To the charge impeding traffic, my apology. Responsible or not responsible?
Responsible.
On that charge, I'm in charge of 150, dismissed it. So the please accepted to allowing licensed driver to drive, please accepted to impeding. The suspend, revoke, denied, and disobey traffic control device are dismissed. 425 or 90 days on the allowing unlicensed driver to drive, 150 on the impeding, 575. Can you pay that today?
I can pay 400 today.
Okay, you pay this impeding now, that's 150. You pay 250 now on the allowing unlicensed driver to drive, and how about if I give you until August the 31st to pay the rest?
Yes, Your Honor.
Okay? If you need more time, call the court, we'll go on Zoom, I'll give you an extension, okay?
Okay, thank you.
Best of luck, thanks.
Judge,
This is going to be on the side.
Dasha Dugas, please. 25 CR 720.
Lucas, Ms. Lucas is here. I've spoken with her. She's in the process of hiring an attorney. Asked her for to give her 4 weeks to get it.
Who is it you're hiring?
Michael Marion, about her.
Okay. You have a motion to revoke probation that's been filed, and we move these very quickly. You've got 2 weeks to get a lawyer for us. If you're unable to afford one, are you working somewhere?
Yes, sir.
I mean, these don't languish long. A motion to revoke probation, we move these quickly. So it's not a jury trial, it's just before me. And you need somebody to get involved in it pretty quickly. Do you understand? Hold on just for a second.
for coming back.
I'm gonna tentatively set, just make sure that that's good, that she has input on it, okay?
Yes.
And then I'll do it that way.
Yes, okay.
And then what I'm gonna do, Don, is reset this. It doesn't, I've got doubts about her financial abilities.
She's done a really good job.
Yeah, gosh, she's behind $7,000
Okay.
with a great job. You know,
Okay.
something's wrong. Something doesn't make any sense. If you can figure it out before,
Okay.
you're a smart guy, help her if you can. But I want to redo the, I want to come back in 2 weeks. Okay, thanks. All right, Joshua Gidry. Joshua Gidry. Paul Phoenix 25 CR 519. Say that again.
Can I have those files, please?
Yes.
Thank you.
This is Mr. Guidry's first appearance. We just visited briefly, so give back a few weeks to consider the offer and.
All right, you're Mr. Gidry.
Yes, sir.
Here, 25 CR 519. You have been indicted recently by the Jefferson County Grand Jury for the second-degree felony of assault on a peace officer. And that carries with it up to 20 years in prison. So it's obviously something that has to be taken most seriously. And are you, were you retained, Don, or are you?
No.
Do you have a job or something? Are you able to hire a lawyer?
So
You're not, why not? You don't have an income?
I'm going to school right now.
Doing what, sir?
Well, I'm going to say it for the pipe service.
Okay. What was the last employment you had? Because you're 38 years old? Yeah. When did you work last? When did you have an income last?
Before I went to jail, that's how I lost the job.
What was the job?
I was
Pipe fitter?
No, I was reporter, working at an apartment complex.
Okay, so you're trying to get your pipe fitters.
Yes, sir.
Okay. Man, I think felony offenses don't help. To get your now I know I used to represent the pipe fitters when I was in private practice, and they're all a good group of people, and they generally don't commit crimes. So you need to fix this with your attorney. Do you have any prior convictions? You do? What are they?
He's got a delivery of a controlled substance in 2015,
What was the disposition on that?
7 years prison.
There's not an enhancement there.
No, sir, not yet.
No.
And evidently in fact listed, and then there's a prior position that he got 6 months state jail.
Okay, according to the prosecution here, you have a prior conviction, which if what is generally done is prior convictions are researched generally a lot of times after indictments, when they discover that there's a prior felony conviction, it can be added to the indictment, which means this second-degree felony can turn into a first-degree felony if you have a prior felony conviction. Then you're looking at up to life in prison. And that's what I see coming down the pike, because that's what's generally done, is they add prior felony convictions if it's allowable. And here, you committed this offense after your other felony was after you were convicted, and that was final. So you're probably going to be looking at additional exposure. So and when that happens, if they re-indict and it's increased, your bond's going to be increased too. You're going to have to deal with that. So you and Mr. Dusler here probably ought to figure out how you can do some damage control. And he's a sharp guy. He knows how to help people. So and until that time, well, we're going to reset it for 3 weeks for review of where the status is on this. Because there's nothing we can really do until that, if they're going to re-indict, that has to be done or it will interrupt the proceedings. And you need to know where you stand on where they're headed. And they just, they have a right to add other convictions if they're, if they can enhance the punishment, and that's what happens. Nothing good here, but you need to know where you stand so you can deal with it. All right, I'm resetting it 3 weeks, and I would stay in touch with your attorney here.
Senate reset and wait for me also.
Sharon Lee. Sharon Lee, please. I have 2 cases on this lane. What are we doing here?
He is in the process of hiring Lane Webber, asking for 4-week resetting to do so.
Is that right?
Sir,
Is that right?
In
You're
the
hiring?
process of hiring Lane.
Lane Walker,
When is that going to be done?
I spoke with him yesterday.
I know when is, but speaking with him, generally you have to,
Within 2 weeks. Oh.
yeah, make some payment and
Yes, sir.
to hire them. Do you understand the seriousness here?
Yes, sir, I do.
Okay. Just not 1, but 2 first-degree felony indictments. You were looking at up to life imprisonment on each case.
Yes.
Each case. They're all serious in this one.
Yes.
First-degree felonies or murder, capital murders, capital cases are the most serious. Let me ask you, what was the bonds? What were the bonds in these 2 cases?
$8,000.
You paid 80,000, you paid 80,000 on each case?
No, sir, 4 and 4.
And why haven't you hired a lawyer if you can pay $80,000 for a bond?
Pay $1,000.
Who did?
Bondsman. Yes, sir.
No, bonds, no. What you paid somebody, they don't just,
And now,
you know, maybe when I speak, you should be quiet. Because she can't take both of us speaking. And when I speak, if you'd be so kind not to rudely interrupt. Because what I say is very important for you. I try not to waste words. You posted an $80,000 bond. Okay. It wasn't 80,000, but it was 80,000 in cash, but you had to hire a bondsman. And I know what it costs them. If you can come up with that kind of capital, why are the taxpayers paying for your lawyer here? That's my question to you. You need to pay for your mess that you've gotten yourself into. The taxpayers don't think they ought to pay your way. You haven't hired him, right? No, he's an appointed lawyer. The taxpayers are paying for him. You were able to post an $80,000 bond. I want you to go hire your own lawyer. You've got assets somehow. Don't look at me like I can't believe it's butter. I mean, what's it? You got this physical look about you.
I didn't pay.
He's representing you.
I've never spoke to him.
You haven't? Well, go
until
hire
today.
your own lawyer.
She's working on it.
Yes.
Okay.
We met today. She advised me
Okay,
she's hiring.
he's the public defender. He is appointed by the people. You're supposed to have your own lawyer, you know, and that's what most people have up here. Maybe you didn't know that, but that's the people are going to pay for the lawyers when you have the ability to post $80,000 bond. That's just math. You got to, just like me, when we make a mistake, you got to fix it on your own. And sometimes it costs.
Yes, sir.
But you need to go hire your own lawyer if you can pay that. And Don Dusler is not going to continue to be the appointed lawyer by the people. He's paid by the people. And but he's got valuable advice while you've got him here. All right. You got, when are you going to hire Mr. Walker?
I'll speak with him when I.
No, when are you going to hire him?
3 weeks. And
Yes,
two
sir.
hearings.
You
I
say
think we're
3,
going to payment. Yes, sir.
3 weeks?
Yes, sir.
Okay. So I'm going to reset this in 4 weeks.
Yes, sir.
And you're going to get a resetting. Give it to him or whoever you hire
Yes,
so that they know when the next event is, so that they can properly. Yeah, there's a way of formality getting into the system to represent you, and you want, they need to know that. So give that to them. We're going to give this to you. Get a reset.
Yes.
4 weeks.
Just yeah.
I like that speak.
Justin Moore.
I was told this morning that that his boss was notified your clerk that he's in the hospital. She just told him.
Well, like, what's he doing? Is he,
He was in the
is it custodian work?
I don't know. Your coordinator told her this morning.
Okay,
She was just notified by the bondsman.
okay. We're going to call Justin Kyle Moore. Justin Kyle Moore, 3 cases, 23 CR 1784, 23 CR 2027, 23 CR 2028. Justin Kyle Moore. There is no answer in the courtroom. I'm asking the bailiff to call into the hall, please, for Justin Kyle Moore.
Justin, Kyle, or Kyle, or.
Oh, places too.
No response, Your Honor.
There's no response to the name being called here in the hall, in the courtroom, and no response to the name being called into the hall. Defendant has failed to appear. What are his bonds? I'm going to make tentative findings and verify that he is unable to be here because he might be in the hospital. And if
Yes.
that's true, then that purges him. But
I understand. So on 1784, it's $5,000. On 2027, it's $7,000. Now 2028, it's $15,000.
okay, each of those bonds are doubled for failure to appear, and these are tentative findings. And if he's unable to be here, of course, for hospitalization reasons, that purges him. And the warrant will be issued for us to big arrest, but we will hold those until we know for sure. You don't know why he's in the hospital? Right?
No, I mean, Ellie just told me it's, that she just got notice from bondsman.
Mhm. Okay. Megan Presswood.
Yeah.
Megan Presswood.
My understanding from Ellie again this morning is that he is.
She's in the hospital?
He's in jail in Louisiana. She is in jail.
She's in jail, yeah.
She's in jail.
She and a co-defendant have some more charges in Louisiana that I think the federal government is also picking some more.
Are you, the feds have them?
I don't know if it's state or federal, but I know there's stuff in both states. And she was in
It's state right now, but there is a.
Okay. 25 CR 513 is called again. Megan Mackenzie Presswood. There is no answer in the courtroom. I asked the bailiff to call into the hall for Megan Mackenzie Presswood, please.
Megan, you can. Megan, you can be.
$25,000 bond. I think.
No response, Your Honor.
There's no response to the name being called here in the courtroom, and no response to the bailiff's call into the hall. Defendant has failed to appear. Tentative findings here will be made that a warrant shall be issued for her arrest. Her bond of $25,000 is revoked, and it is now $50,000 plus. She must have a GPS device as a condition of bond, and those GPS devices are also required whenever the court revokes the bonds for failure to appear. But we're going to hold all of that to make sure that she was unable to be here because she was in a federal custody. The defendant is charged with the promotion of prostitution, a third-degree felony here in this case, in this court, which carries with it up to 10 years in prison. So it is a serious felony, and those findings tentatively will be executed if the court verifies she was able to be here. Okay. I think that's it. For time being. Carisha Joseph, please. That's 25 CR 743.
Morning.
Yes, Smith. You or Ms. Joseph? Okay, you were charged with the second degree felony of assault on a peace officer, which carries with it up to 20 years in prison if convicted. Very serious. And Ms. Manali is representing you at this time. What do you want to do today?
Judge, I need 4 weeks.
You need 4 weeks?
To go over the media and relay them all.
Telling you most questions.
Work with her. She's a very nice lady and very competent, and she'll help you. She's your lifeline in this. Are you still at 4150? Is that your address?
4155.
Okay. I had 4150, but it's 4155.
Yes.
And the number I got 123.
Yes.
I guess they just did this wrong. Okay, we corrected this. And please get a resetting. Thank you. Jesse.
Ma'am,
Right here, that lady. Jesse Fan.
Oh, I did that.
Fan. On.
Raise your right hand. Where or from your face.
Okay, 25 CR 334 is now called. Jesse, is it Kuyat? And your last name is pronounced Fan? Oh, all right. Ciao.
Hello.
And Ms. Minaldi, very good lawyer, representing you. You were charged with the state jail felony of theft. Hello. Oh boy. Yeah, second page is and third page go on. You're charged with theft. And if you have 2 or more prior theft convictions of a felony, or above a Class C misdemeanor out of courts in Texas for thefts. If you have 2 or more, then if you steal a pack of gum, it's a state jail felony. You're looking at up to 2 years just for that. So it's not a wise thing to commit thefts. You were convicted in 2014 here before me. You remember me?
I remember just her. My very first case, you said it to me like 18 months.
18 months?
I didn't respond to what you asked me a question. I was young at the time, and I didn't know how to answer it.
Well,
And like,
that was, it looks, well, I'm kind of disappointed because
I just been drugs and all my life, man. I was afraid about that other one.
you committed 12 thefts in courts at law or district courts since you were in my court. 12. And then now we've got another one here. So it's a state jail felony. So you were looking at up to 2 years in state jail. So today,
Judge, I'm in conversation with Ms. Staub, but that has obviously ceased this week since she's out at conference. I need to talk to her about an offer and see what that looks like.
so you talked to her and she immediately left town.
Yeah, she just ran out on me.
I'd like to have been present at that conversation.
I'm just joking. Ms. Staub is great.
How much time?
4 weeks.
4 weeks, okay. Get a resetting is. Jesse, don't steal. Don't steal.
Yes, sir.
Be honest.
I'll wake up and think about doing just the drugs. There was ready to go.
That's not an excuse. Don't use drugs.
Yeah, I'm not.
Okay, fix this.
Highlighted that for me.
Otis Pollard.
Fill out the
Otis
thing.
Pollard.
Even if this is 0, we have no income and no expenses, you still have to zero, okay? That you could. How was
The way this is.
Did we have an add-on today on this initial document?
Yeah, so
Okay.
that's the defendant from Monday that had to get a GPS device and we just needed to confirm that he has a GPS device and sets in
Okay.
restrictions.
All right. Otis Pollard,
Yes, sir.
2 cases here, 25 CR 138 and 139.
It's for the or term, which information is from
Oh, boy, we got some priors here. On 138, you were charged with the 3rd-degree felony of unlawful possession of a firearm by a felon. So it looks like you have a burglary of a habitation according to this conviction out of the court next door, 252nd in 2001. Thereafter, that was final. This state you were convicted in that court again in 2011 for burglary of a habitation. After that became final, you were convicted in that court once again for assault on a public servant. 3 priors. This means if all of this was true and you were found guilty, you're looking at no less than 25 years in prison up to life in prison. Do you understand?
Yes.
Habitual felon. Now we go to 25 CR 139. You were charged with a state jail felony here. And the 2 priors make it a state jail. 2 prior thefts, misdemeanors. Again, like I was telling somebody before, if you steal a pack of gum from now on, it's a felony. And you got this is a legend in sequence, burglary of habitation and the 2nd-degree felony, another burglary of a habitation, 2001 and 2011 out of the courts next door. So this felony, state jail felony, can be enhanced to second-degree felony punishment. So this is not good. You're looking at life in prison, up to life imprisonment on one case and up to 20 years in prison on the other. So you understand?
Yes, sir.
Okay. You've fallen in a minefield. You got to tread lightly and responsibly to navigate through this mess. She's your lifeline. What are we going to do today?
Judge, I need 4 weeks. I'm not receiving action case and I also meeting that we want to review.
Okay. Get a resetting in 4 weeks. Might I have Matthew Graham, please? Matthew Graham, thank you. 24 CR 425.
Just. You must be a drink. Right there, let me get this. And then I'll. Okay. It's on, I like it.
And Mr. Graham, how you doing on, it was a GPS we needed, right?
Correct.
You got that?
Yes, sir.
Okay. How's that working for you?
It's existing.
Yes. So it's on your ankle?
Correct.
You got to be careful in the tub.
That's
In the tub. What did they tell you? Did they tell you how to deal with it?
Only waterproof.
It is waterproof. That one is good. They're doing, that's good. They're modernizing things. Probably people had to kind of wrap their leg when they took a bath or a shower.
The GPS company wants to know what restrictions are, if he has a curfew, where I guess he's allowed to go, that kind of thing. So we can send that for the company so they can have that in place.
Who is representing him?
There's Tuesday.
That's that name.
And we had to replace Mr. Dukesler.
Yeah.
Is it Megan?
Mr. West.
The conflict. So we have now appointed Mr. West, who's on vacation, but we had already had this set.
Okay. Okay. One of the conditions of bond is you've got to, until we can sort this out here, Mr. Grant, you're going to be on what we call house arrest. You got to stay at home except for work purposes. And you are allowed out for purposes of work, purposes of getting food, purposes of medical. And that's to and from the most direct route, by the most direct route. And you have to inform the company you're about to go. You go to work as well, and you are clear for work purposes, 6 a.m. to 10 p.m. So that ought to give you, and you obviously cannot have any contact with the complainant in this case. That would be a catastrophic mess. What would happen is your bond would be revoked if we discovered that, and you would not get a bond. You would have to sit that out in jail because of the nature of this case and the importance of making sure that the victim is not subject to any more possible harm. Fix this.
Yes, right.
And I'm going to reset this. When's John coming by? I should, well, probably. Yeah.
John, but he'll need a couple of weeks now.
And we're in 3 weeks. Reset for 3 weeks. Okay. Get a resetting. So thank you.
Yeah, I'm sure they'll also, especially out there.
Joshua Gidry,
Together.
come on up. Sir. In 25 CR 519, you were Joshua Gidry, and Mr. Dusler is here representing you. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, Mr. Gidry, you probably are intimately aware that this states in an indictment handed up on May 7th of this year, this states that on or about March 7th, 2025 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. Do you understand what you were charged with? Ms. Wilson? Yes.
Yes, sir.
Okay. And if convicted of a second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached between you, your attorney, and the state that you would be pleading guilty, be placed on deferred or unadjudicated probation for up to 10 years and limit fine $500. It means you would not be found guilty so long as you followed the terms and conditions of probation, which are normal and customary for all probationers for the most part. If I follow this agreement, you have no right of appeal of your case. Do you understand? If you touch we can't wait.
It's very sensitive these days.
You touch it anywhere, it closes out. These were the new and improved pads that are less improved and aren't new. Yes. How do you plead to this, sir? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1 here. Did you sign that? We can have that silence. Did you sign that
Yes, sir.
document? Does that sit with your attorney or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offense. You were given your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God, it states.
Yes, sir.
State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report.
Yes.
I am going to follow this agreement, if nothing further to add, and find it. Mr. Guidry, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. Even though there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, I am instead going to defer any finding of guilt and not find you guilty so long as you follow these terms and conditions of probation. Make sure you do. This will be for a term of 10 years. You do well, it gets shortened to 1/3 of that, 3 1/3. And these terms and conditions of probation are normal and customary for people like me. Although we've added anger management class that you must take as a condition of probation, which is a good thing. It helps you think and control your emotions when you're vulnerable. It's good for everybody, actually, to take. There will be a fine here in the amount of $500. Make sure you follow these terms and conditions of probation. If you fail, your probation could be revoked. You could be then found guilty and sentenced up to 20 years in prison. So there's a lot of writing on working this thing out well. Okay. All right. Please see the probation officer. Thank you. Okay. Give me some time. Thank you. Deanna Baker? Sure. Come on up, please. Morning, John. Yes, sir. Good to see you, Chris. Good to see you. How are you? And you're Miss Baker?
Yes, sir.
You were here with your attorney, Mr. Papatin.
Yes, sir.
And we are here, looks like it's an announcement. What are we going to do?
Just we were to get a respectful request.
How much?
40 and 60 days.
How about 6 weeks? This will settle out for.
That's okay.
6 weeks? Okay, y'all are working on something, maybe. We'll see.
Yes, sir.
Okay. 6 weeks going to be good enough? Everybody's?
Yes, sir.
Okay, why don't we just set 6 weeks and return back and make sure he's your lifeline. Talk to him if you need any resolvement or clarification on things. Okay, follow his advice. He's a smart man.
Okay, thank you.
Please. Get a resetting. William Padilla. Padilla. Mr. Cartwright?
Highlight it out for me, please.
Seriously, I think Mr. Carter, we're going to fill out the papers on this patio.
Okay. We're gonna, are you Mr. Patio?
Yes.
Okay, Mr. Cartwright is working with you right now? Okay, y'all are working together on something. Let me know when y'all are ready.
Yes, sir.
Take some other matters up. I have next, Jameisha Butler. It looks like that had with Mr. Consul, that has been reset for 2 weeks. Richard Cook is next. Richard Cook, to be dismissed, this says. I mean, Mr. Galmore is the attorney. Y'all have anything on that? Steve? This says to be dismissed. Have we done that? Let me see.
So it's a mistake.
Who is? Mr. Boyd?
Yes.
Sitting there quietly, aren't you?
Checking the notes. He's hiding from me. He didn't know how I love his muscle.
He's hiding clearly in the presence of everyone.
That's to be dismissed once restitution is.
Yeah, Your Honor.
Is that what it is?
I'm not sure that, we don't have any proof yet that the payment has been made. I believe
Well,
that's not a restitution that was.
Well, where's Mr. Cook? He's living in Joshua, Texas. That's just not across the street.
I saw Mr. Gallo on stage.
Yeah, I know, but where's he? Not here. All right. We'll call that one again. Find out what the deal is.
Well, there Mr. Gallo.
Mayor Judge, sorry. Upstairs.
Is it Richard Cook was up to be dismissed?
Yeah, so my understanding of it is there is a cashier's check in the mail.
For you?
Correct, well, to bring to the district attorney
Oh.
office. Mr. Cook works in Colorado.
Yeah, that's a long one.
So he was not planning on being here.
Okay.
So I told him that, obviously if we don't have the check yet, the warrant may go out.
But it's on its way.
He says the check
I
is in
know,
the mail.
but can you verify that for us to make sure that, or it's going to be here in the immediate future?
I expect it today.
Okay.
I do expect it today, but.
Yeah, but or something like that. I'd have had a kind of some kind of proof from the whoever sent it, messenger, postal, that there's some verification that it will be delivered, because that's a lot riding on that. How much is it?
10,000.
Hello.
But that's the full restitution.
All right, I gotta look, I want to reset this for just a couple of days to make sure that we just don't lose sight of everything, right?
That's
I think it's Thursday.
Next week, fine.
Monday.
That's plenty of time.
Monday. Okay.
That's all.
You didn't put it off like a horse or anything.
I don't believe.
I mean, like it's being delivered by horse or something. Laban Golo. Golo, I think I'm pronouncing this right. Golo.
Should I get on right? Yeah, sure. Thank you.
I need just some more.
You want like a stack?
Are you, Laban Golo? And in 24 CR 1314, you were charged, and by the way, Mr. Grove was your attorney, correct?
Yes, sir.
You were charged here with a second-degree felony of aggravated assault, and that carries with it, if convicted, up to 20 years in prison. Very serious. So what are we going to do today?
Judge, we're going to ask for some more time, trying to obtain some records, and a person that works for CPS, we've not been able to locate this person yet, or the records that she has. But I think we should do so. We could have a couple of weeks.
Two?
Yes, sir.
Okay, we said 2 weeks. They're setting things. Braden Hensley. 24 515. Mr. Hensley here with Mr. Grove, and you're charged with this third-degree felony of, well, it's not a good charge.
Yes, sir.
It's got to be a source of embarrassment for anybody. But deal with pornography. So today announcement.
We could have a couple of weeks, Judge.
It's too good. Two, is that what you're asking?
I'm sorry, Judge, the plan before we
2 weeks. Reset. 2 weeks reset on this one too?
Yes,
Is
sir.
that right? All right, then we can get a reset. So here, Mr. Hensley, right there.
Yes.
Patricia Johnson. Patricia Johnson, please. Okay, this is. All right, you're charged with a state jail felony of abandonment or endangering a child here, which carries with it up to 2 years in the state jail if convicted. Serious, and it's a felony. Well, Mr. Grove is your attorney today. Announcement.
You have 2 weeks on that one also.
The 2 week day today, huh?
Well,
2 weeks.
I'm trying to get things in for the end of the month.
Okay. Get reset for 2 weeks, please. Please get a resetting, man. We'll see you back in 2 weeks. Akaya Lane, I think I'm pronouncing this correctly. ACAIA. Akaya Lane. How do you pronounce your first name? Akaya. You have been for the third-degree felony of credit or debit card abuse of an elderly person, which carries with it up to 10 years in prison if convicted. So that's serious. Mr. Grove is your attorney today. Announcement.
Yes, sir.
2 weeks.
Yes, sir.
Okay. He's going to try to get more information and help you on this. We're going to reset this for 2 weeks, man. For 2 weeks, please get a resetting from that lady. Thank you. Carson Moore. Carson Moore, please.
I have to work it out on sheet of paper.
25 CR 497. You're Carson Moore.
Yes, sir.
And Mr. Grove, also is your attorney here.
Sorry, Judge.
That's okay. But thank God. What a Rick.
Right?
All right, this is an announcement here. You've been charged with second-degree felony of assault on a peace officer here. And criminal, what is your criminal history, Annie? You need to fix this. This is fixable. Just don't do something like that again, you know? Yeah, but anyway. Yeah, you need video footage. Okay. We can all use video footage, but your attorney's going to take care of that for you. If there is any. Good. Anything, what do you do?
I would say too, you should.
All right.
Be able to find by then.
Okay. Mr. Board, you're on this one?
Yes, Your Honor.
You're going to be able to get any video that might be available?
Yes, Your Honor. We're always ready to hold that.
Okay. Get a resetting for 2 weeks, man. This lady, thank you. Arlena Solomon, please. 24 CR 1361.
What's the problem, ma'am?
And Ms. Solomon, as you know, I think we talked about this last time, you were charged with a second-degree felony of aggravated assault, which carries with it up to 20 years in prison if convicted. Mr. Grove is helping you. If your attorney today, what is our plan? We have the two week rule.
2 weeks, yeah.
The 2 week rule.
Hopefully.
Okay.
If the information by then, you know.
Reset here. Get a resetting, please. Jackie Williams. I think I'm pronouncing this right. Two cases. That you?
Yes, ma'am.
All right, Mr. Williams, you probably know this, that you were charged in two cases, 25 CR 151 of the state jail felony of attempting to take a weapon from a peace officer. That carries with it up to 2 years in prison. In a state jail felony. It's a state jail felony, a state jail facility. And then 25 CR 152, you're charged with the second degree felony of assault on a peace officer, which carries with it up to 20 years in prison. It looks like this was out of the same event.
Yes.
All right. Mr. Grove is your attorney here. What's our plan today? Let me guess. 2 weeks?
Yes, sir. Court would allow that.
All right, 2 weeks. Reset this 2 weeks. Thank you. You get a resetting. Thank you.
Yeah.
All right, Brittany Holmes, you're up on Joseph Davis. Thanks, David, for getting those taken care of, whatever you can do. Mr. Davis?
Yes, sir. Please.
Is here. Ms. Holmes is your attorney. Today, what's our master plan?
Rick is open as a new prosecutor. So
The new prosecutor?
well, familiarized with the case.
New would not have been my adjective out of you.
Yes, sir. If we could get a few weeks, I think we'll be able to get this skills.
It's like October of last year. It looks like it was invited.
Yes, sir.
So how much time do you think? 3 weeks? Glenn? That's good. Okay. Get a resetting, sir.
Thank you.
Thank you. Mariana De Hoyos. That's Mr. Jeffries. There you go. Looks like that's the only one with her. Yeah, you got some other ones for me.
Correct.
Yes.
Okay, there's an announcement today here on this one, 24 CR 2104. You were Mrs. De Hoyos? Okay, you're charged with a third-degree felony of engaging in organized criminal activity, which carries with it up to 10 years in prison. Serious. Today, what are you going to do?
I've been, excuse me, been communicating with Mr. Ham, recently, kicking around a few ideas. We just need probably a few more weeks to sort out.
2 or 3?
3 is possibly.
4 or 5?
5 possibly.
No, what do you ask? Really? What do you?
3 should be.
Is 3 good? Okay. Oh, please get a resetting, man. Thank you. All of your attorney's advice. We got some smart lawyers in the room today. Dustin Russell. Dustin Russell, 24 CR 385.
It's a plea, Your Honor. I don't know if you have paperwork yet.
I don't.
He needs to come swear and fingerprint in front of me before I can.
Yeah, there's a formality we got to go through.
The paperwork. There's that.
I'm going to look ahead because this one's a cluster. The next one is Alberto Zambrano. We call this a gaggle of cases.
That's fair.
Look at the 8. Okay, you. And then we've got another gaggle with Tom.
Yes, yes.
Later, here in a minute.
Mine's not a gaggle, Judge.
Yours isn't a gaggle. Yours is more of a giggle.
I agree.
Place it black there.
Can't believe they even filed it.
Can you get up one more time?
Hey, I laughed on that one.
That's all right.
That was pretty good.
Yeah.
Mike's not flat.
Judge will call you soon.
Alan had a funny joke. No, it was pretty good. It was all about you.
Good. You gonna wrestle back up or? And
Dustin. Okay, 24 CR 385 is called the state of Texas versus Dustin Russell. That's you, sir?
yes, sir.
And present with Mr. Jeffries, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Again.
In summary, this indictment alleges that on or about October 16th, 2023 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand, sir, what you were charged with?
Yes, sir.
If convicted, this is a third-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached between your attorney and the state where one page. Where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for up to 10 years. And there's no fine here, it looks like. Is that there would be terms and conditions of probation, which are normal and customary. You do well on it, you get reduced, it gets terminated in a third of the time, which would be 3 1/3 years. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand? You can't get rid of these pads fast enough. I mean, if you just. I'm left-handed, so I have to touch, I right. That's the way we learned in school in those days. It's just that. You touch it and then it just smudges and. Yep. Never had pads like that before, but these were the new and improved ones. They did. But they're very sensitive. Again, how do you plead to this, guilty or not guilty?
Guilty.
Are you and your attorney both pleading guilty on this? Voluntarily. And I know, not to make light of it, but you would look for him for advice on that.
Yes.
But are you pleading guilty voluntarily and upon discussions with your attorney? Okay. Then I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document? voluntarily, understand it, discuss it with your attorney, or the contents all true and correct. States Exhibit 1 is tendered into evidence
No objection.
and without objection admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. States Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement, sir, and find you are guilty voluntarily, knowingly, intelligently. You are mentally competent to do so. There is sufficient evidence supporting your guilty plea from States Exhibit 1 here. Admitted to find you guilty beyond a reasonable doubt of this offense. I now find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. However, that confinement will be suspended and you are placed on regular probation, what we call regular probation, for 10 years. And there will be terms and conditions of probation which are normal and customary for this. One of the conditions of probation, you must complete a defensive driving class. And that's a win-win, really, because your insurance will be reduced a pretty good amount by completion of that. And other terms and conditions which are normal and customary for this. And the probation office is going to go over them with you in just a minute. Sign this. Make sure you follow them. If you fail, we don't like to talk about it, but if you do fail, you can be sentenced up to 10 years in prison. We don't want that. You don't want it. So fix it. It's fixable. You just do what you're capable of doing and you'll be fine. Okay. Yes, sir. Thank you. Yes, sir. Alan Parker.
Jones.
For us to files back.
Okay, I have Correa Jones. Correa Jones. And you were here with your attorney, Mr. Parker, and the state's attorney is here in 23 CR 2009. An announcement. You were charged, as you know, with the state jail felony of theft of property, which. Oh boy.
It'll be a third degree, Judge.
Well, it'll be a state jail felony, but it'll be punished as though it were a third degree. You will be punished that way, but it will show state jail felony, and then the third degree punishment means that you're looking at up to 10 years in prison. So that's very serious, obviously. What are we going to do to that?
I need about 30 days, Judge. I got some video. That's good.
You got it?
Thank you, Judge.
Okay. That's what he said.
Oh, good. So you know about being a grandfather, right?
Albert, no.
But yeah, like any day. And we was hoping to be yesterday, my dad's birthday, but they're going to name him Parker.
Oh, man, what a great thing. That would be wonderful. Well, congratulations to you all. Is that your first?
Yes.
I'll be done.
You can imagine Andrea. She's up there waiting.
Alberto Zambrano.
Yeah.
Did Alan say he was, if it was a boy, he was going to call him Parker? Parker?
It's his daughter's having them.
Yeah, Andrew, his daughter. That's his grandchild, first grandchild. I was just throwing that out there. He said Andrea's out there while his wife's looking for him. They seem pretty excited. All right, you were charged with 8 cases, right? And these are all very serious. 24 CR 2065, 2066, 2067, 2068, 2069, 2070, 2071, and 2072. Are they all second-degree felonies of sexual assault of a child?
Correct.
Same child or different children?
Same.
Same child in each of these. Each event is a separate offense, and can be indicted separately. So, what's an announcement? What are we going to do today?
I'm just requesting more time, Your Honor.
How much time? What do y'all think?
I think probably 6 weeks, Your Honor.
I was going to say 5 or 6 weeks. We'll figure out some more.
Is there a familial relationship with the child and the defendant? No. You can't have any contact with a victim until the case can get resolved, nor anyone on your behalf. You understand? Yes. Okay, 6 weeks. I'm on things. Reset. Thank you.
Thank you, Your Honor.
Yes, sir.
You're on.
I'll be in retreat. That's it.
Doesn't scare me. Andrew Barnett,
Every question?
do I have a choice?
Yes.
Yeah, come on.
Thank you.
If I have a choice, I say, come on up. Mr. Baird, I think is on this one.
Correct.
What are you doing today?
I'd like to ask for some more time, Judge. Maybe 6 weeks.
It's a year old, over a year.
Yeah. We've spoken.
We're about to the point to whether it's either trial or plea. He gave me a list of witnesses and we've about spoken to every one of them. And so we're down to the last ditch effort here.
How much time?
6 weeks, please, Judge.
Oh, you got it. Fine. Also, again, sir, I don't know if you know, were these strangers
Oh, no.
or did you know these people?
Stranger.
Okay,
Yes.
because you can't have any contact
Understood.
with a victim. Okay. No, we're having problems with that. But
Understood.
okay, thanks.
Yes.
Yes, sir. And
Why did that?
Mr. Curtis,
He's present.
we got a gaggle on 4. Looks like cases.
Thank you.
On Mr. Curtis. I got 4 cases, 24 CR 459, 460, 461, 462. You, Joshua Curtis. And 2463. Thank you. Worse than we thought. We got a first-degree felony involving child pornography. The first one, a state jail felony, invasive visual recordings. First degree carries with it up to life imprisonment, and another state jail felony. Third state jail felony. State jail felonies carry with them on each case up to 2 years in the state jail. And then we have a burglary of a habitation in 24 CR 2463, a second degree felony, which carries with it up to 20 years in prison. Okay, these obviously are serious. And announcement.
I suppose these indictments will be reassigned if they haven't been yet, Judge.
Yeah.
And that's the court just.
Yeah, they're going to be reassigned for sure.
Yeah, just mentioned there are a number of them, so I'd like to ask the court for 6 weeks.
Okay. Who's going to get them? Do you don't know?
Not sure yet, Your Honor, but we should know shortly.
Reset 6 weeks. Then.
Mhm.
6.
Yes.
Get a reset on. Thank you.
It's not on the holiday.
Race Hava.
Also present.
Yep.
That's you, Mr. Harris? Is it Hawa?
Oh, let's see, so.
And Race, is that a familial name? A family name? Okay, interesting. I've never heard of a first name Race before. But there's all kinds of first names.
Certainly.
It's no end to them. You're charged with a third-degree felony of evading arrest or detention with a motor vehicle. Have you ever been in trouble before?
No.
Fix it. Fix it. This is fixable, I think. Yeah. Yeah, this is bad enough. It carries with it up to 10 years in prison, but your motor vehicle insurance doesn't treat it politely either. That's what stings too. Anyway, where are we on this?
Your Honor, I've spoken a number of different times with Mr. Ham, and if the court would allow.
Is he the?
He is, Judge. The court would allow us maybe 30 days to.
4 weeks, good.
Certainly.
Okay, reset 4 weeks, please. Thank you. And Michael McLeod. It's another vehicle issue.
Holiday.
On the road again. Oh, that was wrong. It was, I thought it was timely. Oh, where's Michael? You right? Michael McLeod? Oh, boy. You didn't see him? Do you know?
What do you get with these?
24 CR 1976, Michael McLeod. No answer in the courtroom. Who sent it for? I asked the bailiff to call into the hall for Michael McLeod.
Open.
Michael.
Span. That's Span.
Yes, don't have anybody show you.
Yeah. That's it. Working as a unit. Yeah, good thing. You got a family.
Says it has a U-turn press.
A lot of them don't have much.
Let me refresh mine.
Is he here? He's not here? Oh boy. Appear, okay, last time? He would have had to have then revoked and then filed would have then paid another bond for him to really get on the docket like that. That's it.
Unless we receive something in the bonds, but sometimes people recall those forfeitures. Because we
Okay.
receive something from the bondsman. I don't see anything scanned into the file.
There has to be a warrant out for his arrest then.
Don't show one, and I'll have to go maybe dig through emails between Ellie and I and see if bondsman emailed us something. I don't know.
See, this is odd because it was on 6/19. And then it was reset until 8/7. But why would I reset it if it was a bond forfeiture?
Go pull the docket real quick and see if I can have an answer for you, Judge.
Because Yes, stand by, Tom. Let's just figure this out. So I know what, if I have to resolve another bond issue, or if we just need to get the warrant out going for him. Is Charlie, let me talk to Charlie.
Step away for a minute, Jim.
Yeah, thanks. Charlie Rojas, yeah, Charlie. What have we got? Today I'm in a good mood. Adolfo Sanchez, 25 CR 95. Mr. Rojas is here representing you. You are Mr. Sanchez? Correct? You were charged with a third-degree felony of assault. Is it family violence here? All right. Announcement.
It's a relatively new case, Judge. I like about 4 weeks on.
Yeah, 4 weeks. Mr. Sanchez, do you understand you were charged with harming Jessica Escobar Mendoza? How is she related? Wife. Do you understand you cannot have any contact with her until this gets resolved? Do you understand? Yes. A lot of people say that, and then we catch them having contact with the person. If I found that out, I would have to revoke your bond, and you would have to sit this in jail until this gets resolved. You got to fix this in a responsible way, and Mr. Rojas knows how to help you get through this. Follow his advice, but don't have contact, nor anyone on your behalf contact. This happens a lot, and the people, sometimes they don't complain, but if they do, it's a crime. And you lose your bond by trying to influence a witness like this. And we all want to try to help the family unit stay together. People make mistakes. When you make mistakes, everybody does it. You try to fix it in a responsible way. He'll help you do that if it needs to be repaired, because you're presumed innocent under the rules. I'm pretty sensitive about that. And but nonetheless, I'm also sensitive about a family unit trying to stay together. Family special, but it's what you make of it. You got to make something that's special, but you also have to keep it special by the way you act responsibly as a father figure or husband figure. Okay. How much time did you say? You got 4 weeks. Okay, John. Thanks. Maria Mejia. Oh, boy. Okay. That's you, ma'am? Maria Mejia? Okay. In 25 CR 210, you're charged with the state jail felony of operating a motor vehicle while intoxicated with a child passenger. If convicted.
Yeah, no, I'm sorry. She speaks a little bit of English.
Oh, are you helping?
I'll do it.
Okay. No, she's looking at up to 2 years in the state jail if convicted. Serious. Very serious. What are we going to do?
Yeah, again, I need to check out some information.
This was a major accident. What? There was a blood draw. What ended up resulting in that one, Mr. Boyd? Can you tell?
It was a 0.16 is what I read.
Oh, boy. That's too bad. Okay, 4 weeks?
Yes.
Okay. A reset 4 weeks on this one. Thank you.
Thank you.
Yes, sir. Thanks, Charlie. Good to see you, pal.
Yes, sir.
Arthur Gilder. Mr. Gilder? Yeah, you gotta have your lawyer.
Mr. Wilderson said he had to run upstairs real quick and he would be right back.
Sleep ring in the patio.
Okay. You know, I'm holding, hey, Tom, Kelly? Why am I holding Michael McLeod?
That's the one, Judge, we're trying to figure out what happened with the bond. I have Ellie looking and seeing
Okay.
what happened with it.
Okay.
We can't figure it out just yet, but it's working on it.
Okay, who is our plea on?
Queen patio.
Padilla.
I have them go right here.
Yeah. Okay.
He needs to come see me first.
Mr. Padilla, come on up. Come forward. Mr. Cartwright, y'all.
Raise your right hand, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, help you God?
I do. How you doing,
That's the
bud?
right thumbprint.
How you doing?
I'm going all right.
Oh, you
Right
okay?
there. You get up one more time.
How was the trip over?
Nice.
Oh, okay.
Okay. Who was being projected?
Okay. All right, Mr. Padilla,
Yes, sir.
you got, what, we've got a lot of cases. What are we going to be?
We're pleading to the first three and then dismissing the last three and. just defer
106,
probation on each
107, 108.
Yes, sir.
And then 109, 110, 111 will be dismissed.
Correct, Your Honor.
Right, everybody?
Yes, sir.
Ruben's kind of quiet today.
He's doing the strong silent thing.
Oh, he's doing that silent thing.
Yeah.
Stealth.
Yeah.
He's stealth-like. Six cases are called in regarding William Carter Padillo. Is it patio or Padillo?
It's patio.
Like a patio on the backyard.
Yeah, like Boudreaux, Thibodeau.
Boudreaux, it's French. A junior. You're a junior. And Mr. Patio is here with Mr. Cartwright, his attorney, and the state's attorneys. The defendant is going to be pleading guilty to 3 cases involving third-degree felonies of forgeries of United States Treasury notes or U.S. Treasury matters. And these will be in the 3 cases of 106, 107, 108. Does the defendant, who's here with his attorney, Mr. Cartwright, waive formal readings of these indictments and arraignments? Can we proceed in summary? In summary, Mr. Patio, these all similarly allege that on or about March 18th, 2022, in Jefferson County, Texas, you committed the third-degree felonies of forgeries of United States Treasury.
There were $100 bills, Judge, so counterfeit.
Counterfeit money.
Yes, sir.
That is produced by the United States Treasury. And these were $100 bills. They don't have the same serial number.
Yeah,
but they were
because they were
forged.
yes.
But you attempted to use those forged $100 bills 3 times, 3 different episodes. Is that true?
Yes, sir.
All right. These are third-degree felonies, each of these, which means you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed in each case. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty in each of these, placed on deferred or unadjudicated probation? And is there any restitution here?
No, sir.
Okay, you would be placed on deferred or unadjudicated probation for up to 10 years on each of these. These would run concurrently together. If you do well, your probation can be shortened to 1/3, 3 1/3 years. Is that your understanding of the plan? If I follow this agreement in each case, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead to these cases, sir? Guilty or not guilty?
Yeah.
Are you pleading guilty voluntarily and because you are guilty of what these indictments allege?
Yes, sir.
On each of these cases, I'm going to show you what's marked as State's Exhibit 1. Did you sign those documents?
So,
Did you understand them, discuss them with your attorney, and are the contents all true and correct?
yes, sir.
And you sign these voluntarily and based upon discussions with your attorney.
Yes.
State's Exhibit 1 in each case is tendered into evidence without objection.
No, geez.
It's admitted in each case. Among other things, these state that you are, in each case, you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All true, it states, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record in each of these cases. Pre-sentence reports waived?
Yes, sir.
All right. I'm going to follow these agreements. If nothing further to add by anybody, I'm going to find Mr. Patio, God bless you. You okay? I got the worst case of an allergy right now. I got hay fever and I've been almost sneezing the whole time. Now you did that, I'm going to start sneezing. Thank you. You're going to cause me to do this. All right. In each of these cases, I'm going to make the following findings, sir, that you are pleading guilty voluntarily. In each case, you are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted in each of these cases to support your guilty plea, to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. So long as you follow these terms and conditions of probation, you will be on what we call deferred or unadjudicated probation. So you're not convicted. So long as you do this well, follow these conditions of probation. The probation officer is going to go over these. They're normal and customary for this type of offense. Warning, if you fail, your probation could be revoked. You could then be found guilty in each of these and sentenced up to 10 years in prison, which you don't want. So fix this, okay? Do you understand what has happened today? All of these probations will run concurrently. And again, you do well, it can be shortened to 1/3. Yeah.
But I'll be able to get it switched to Houston.
Okay, talk to the probation officer. We would rather you get closer to where you live. It's easier. And we do what's called courtesy supervision, where we have a courtesy agreement with other counties, where if somebody lives there, but they're convicted or sentenced in another county, we work with them and they'll the home county, for instance, Harris County, would take care of it but they have to agree to it, and they generally do. It's easier for everybody because we got some folks from Houston that we're taking care of as well. So we have that agreement going with them. So that can be done. But probation office will go over all of this with you. let me finish all this. We got a lot to write there.
Judge, may I be excused?
Yes, sir.
It's easy.
But if you were doing so, I'm not walking through it. Unless my conference, yes, not his work. Yeah. Doesn't look like he's all ready to go.
One of the conditions of probation, it will include theft, to take a theft prevention class and pass that. That's normal for all theft cases, which helps you make better choices so that this never happens again. It's a good program. I think I've got writer's cramps. Yeah, this lady, she's gonna help you. Thank you. Yes, sir. Yeah, there's not. Okay, 3 cases are dismissed, 109, 110, and 111 on 24 CR 109, 110, and 111 William Carter patio.
The doctors.
We had made all those findings and nothing, it got thrown in the wrong stack, and the defendant was never, the revocation orders I made never were carried out. So he still has a bond that had not been revoked, but it has to be so we can move forward. This is, so I'm going to read Mr. McLeod. We're going to call him one more time at the door. Michael McLeod, 24 CR 1976. No answer here in the courtroom. I asked the bailiff to please call into the hall again for Michael McLeod. Michael McLeod, please. What is his bond?
15,000.
No response?
There's no response to that name being called here in the courtroom, no response to the name being called into the hall. And this is a second event, this a second court setting. The defendant has failed to appear. And there was a mix-up apparently on the previous case where the court made orders finding he had failed to appear, and his bond of $15,000 is hereby revoked again, and a warrant shall be issued for his arrest, and he must have a GPS device as a condition of bond, and his bond shall be doubled to $30,000. But we are going to repeat those findings for today's event where the defendant failed to appear as well. And those findings will be entered in, the warrant will be issued, and we'll take his matter up when he is in custody. Okay. Anything to add, Mr. Kelly, on Mr. McLeod's behalf?
Not today.
Okay, thank you for being here. Sorry about that. That worked out. But maybe he'll be found. He's lost, and maybe he'll be found and be a better person.
Maybe excuse you.
Yes, Arthur Gilder.
You're Monday.
You're Mr. Gilder?
Yes, sir.
Come on up, sir. And Mr. Gilder, you're intimately familiar with, I'm sure that you're charged here with two cases, 24 CR 1095, a third degree felony unlawful possession of a firearm by a previous convicted felon, which and then 24 CR 2383, which was third degree felony of failing to comply with sex offender registration requirements. Each of these carry with them up to 10 years in prison as a punishment, and they are third degree felonies. A couple of things. Number one, on the unlawful possession of a firearm, you're clear that if you have been previously convicted of a firearm of a felony, you have your firearm rights of possession restricted, and you can be penalized. Do you understand? Okay, so, and I think you knew all of that. It's one of the privileges and rights you give up, or lose if you are convicted. And apparently you were convicted here of trafficking of persons in 2021 in this court. So you have ostensibly a felony conviction, which restricts your rights of possessing a firearm. And if you do, you can be punished up to 10 years in prison. So you got to be careful. The other thing is the failing to comply with sex offender registration. This alleges that you are required to register and that on or about October 31st, 2024, well, that's a year ago, going on almost a year, that you failed to comply with the registration requirements under the Texas Code of Criminal Procedure for sex offender registration. And that's a third degree felony if convicted, which carries with it also up to 10 years in prison. Do you understand what you're charged with here?
Yes, sir.
Okay. On this one, are you compliant properly now with your registration?
Yes, sir.
There's not a doubt about it, because if you aren't, we got to put you in custody.
Yes, sir. I have a question.
Yeah.
Does that mean I didn't go up there?
Hold on. Let me, and your attorney's going to get a copy of this if he doesn't already.
Because the way I like you just read it, it sounds.
It says, first of all, I mean, in this probable cause, do you have a copy of this?
I have a copy of the indictment, Your Honor.
This in this probable cause affidavit, this needs to get clear on this one. It says that committed the offense of failing to comply with sex offender registration, a state jail felony.
So,
but it was indicted as a third degree felony.
There are several issues with that, Judge. It appears that the allegation of the violation was failing to provide 7 days advance notice of an intent to move. But I'm unaware of any change.
Did you move? That's, you hadn't. Well,
So in any event, Judge, Mr. Gilbert has since hiring not had the opportunity to come to my office. Now, I will say, I've been on 2 different CLEs, week long or whatnot. Anyway, we just need to reset.
Okay, how much time?
If you could give us 60 days, Judge, that would be good. I've got to get some materials also from David Grove. His case.
Yeah, okay. Is he transferring that? In transferring a case, he's transferring cases to others now, but it was this one he had handled before.
Well, he had been on it, but I was actually retained on this.
Okay.
So, obviously.
Is 6 weeks better? Can you do it in 6? Can you be ready in 6 weeks?
6 weeks, certainly we could be ready with an announcement.
Okay. Yeah, I have your address here as 3835 Stilton Street, Longmont, Texas, on this indictment.
Yes.
And on the other one as well. That's a valid address.
Yes.
That's still good?
Yes.
Okay.
Everything.
Okay. Because
The same address I have down there at the place.
have you seen this probable cause affidavit?
I've had an opportunity to read it, kind of not thoroughly.
This indictment here on failing to comply with sex offenders, the probable cause states that according to police, he's no longer living at 3835 Stilton, and that he did not, then he had been, and they determined, according to them, that he was no longer, I'm not talking in third person, that you were no longer. And thus you had a requirement when you're no longer at a place, you've got to give advance notice to law enforcement so that they can keep up with you. And they said you didn't. I think that's an issue you've got to deal with now. If you're still living at Stilton, then, it doesn't seem, if you have a valid address, that's where you reside properly, then this must be a mistake.
So he was living with a family member, I believe, Your Honor. And so if I recall from our discussion, and I don't want to misrepresent anything, but there have been some sort of disturbance, not anything that resulted in any type of domestic.
So it's a disagreement.
Right, a disagreement, but ultimately there was no relocation, right? No money.
Okay, well, yeah, but then that sounds like something that could be fixed, because you don't want a 3rd-degree felony on you. I mean, that's up to 10 years in prison. And you have that duty to ensure that the authorities who are supervising you over this registration requirement, which I think. Yeah, it doesn't allege. Is he on a lifetime requirement? Yeah. Lifetime? Okay. Well, you don't want to foul up on this because they keep an eye on it pretty closely. And then the other one is this unlawful possession of a firearm.
Situation. And that specifically, Judge, is the one that I learned that Mr. Grove was in possession of some affidavits that I wasn't aware of that I need to get from him. So he's got to go take space from using. Yes, it's a copy in the answers.
6 weeks good?
Yes.
You hear me? Okay.
Yes.
Reset. 6 weeks, please get a resetting.
Thank you, Your Honor.
Yes, sir. Yes, sir. Anything else? We are in recess. Thank you.
Court does call the case of the people versus Duante McFarland.
Robert J. Kill on behalf of Mr. McFarland.
Mr. McFarland, can you state your name, please?
Jonathan McFarland.
Thank you.
Judge, a couple things. I was just appointed this case and then they appointed me on his circuit court case, which the PD had sent him to the forensic center. He came back as competent, but the criminal responsibility is not done. He's got a really long history of psychiatric treatment. I'm asking for an adjournment in this matter. I met with him last night, explained what I was going to do. I'd like to see the criminal responsibility report before we proceed.
Yeah, I don't know when those are going to come through, but I mean,
I'm reading his competency thing, Judge. I don't know how he was found competent, but that being said, I'm asking for an adjournment.
28th are going to potentially be long enough, or you're going to need?
I was going to ask for 30 days, possible.
Probable cause conference, September 11th, 2025, 9 a.m. File continue.
Thanks, Judge.
Thank you, sir.
Thank you.
I'll come down and see you.
All right.
Court does call the case, people versus Stephen Grisbeck.
Bring on Sam Bernstein with on behalf of Mr. Grisbeck.
Sorry. And Laura Yagi, Assistant Public Defender, also with and on behalf of Grisbeck, I believe in his second case.
Oh.
Are you both? Oh, never mind, Your Honor. I got subbed in.
Can you state your name for the court?
What?
I failed to communicate, Your Honor, and I didn't realize I was subbed in.
So do I get my choice as to whether it's you or Bernstein?
Do you want me to sit?
Or, yeah, well, you knew what would happen. I take her, but, all right. So you're on both cases?
Oh, yes, Your Honor. Yes.
That didn't sound real confident.
Yes, Your Honor.
Okay, so you're on both. All right. Well, I don't. Was there an order on that?
Late last night. You should have one each.
I don't have one in this one. But you're saying it did come through. Because I still have Miss Yagi on.
You know, Miss Yagi might be on it now that I'm thinking it through.
On 11/27.
I'll take Miss Yagi back, Judge.
And Miss Yagi on the other case.
She's willing to return.
I don't have a substitution.
Okay, I thought I met with Mr. Grisbeck, so Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Grisbeck on the second matter, Your Honor.
All right. Now that we got that all done.
And Your Honor, I did write a green sheet requesting an adjournment. First of all, because we were subbed out for the second case, but also there's a third case that Mr. Grisbeck has held on that he is going to request to be released to treatment on. It's not before Your Honor today. It's a different case. And so I wanted to follow up on that matter before proceeding on these matters.
Got you. But is it a felony that's coming here or is it someplace else?
No, Your Honor, it's actually a misdemeanor 14A1 that is post-sentencing. So he has already been sentenced to
right before me.
Before you.
I think I remember. So
I wanted
is he right. We can solve that part if you're looking to have him released to treatment on that case.
That is what we're looking for, Your Honor.
Okay. What are we doing on yours?
I would also like to follow Ms. Yagi's lead and adjourn my case, Your Honor. I will fill out a green sheet.
Okay. So that case that I sentenced him on, we don't have another date set on that.
Correct.
All right. So why don't I do this to make it a little bit easier for everybody? I'll adjourn this to August 28th, 2025 at 9. Both of these proceedings. And I'm assuming on his other matter, the public defender represents him.
Mr. Bernstein represented him previously, but I believe as it's post-sentencing, he would qualify for us at this point now.
Okay, so whoever it may be, if he wants to go to treatment, then submit an order to the probation, because he's on probation, I think, right? So submit a request to the probation department so we can get that moving for him if that's what he wants to do.
Thank you, Your Honor. I will do that.
All right. And in these matters, Bob will continue.
Thank you.
Court calls the case People versus James Daniel. Cases. Really?
Sherilyn Foster Tucker on behalf of James Daniel and the case ending in 1339.
Good morning, Your Honor. Assistant Public Defender Alexis Serpswith on behalf of Mr. Daniel on case ending in 1320.
Neither had an opportunity to discuss with him how to appropriately attire himself to come to court.
Your Honor, that discussion will be had after court.
What are you looking to do?
Your Honor, I have submitted a green sheet so that we could ask for an adjournment. We do need to have a conversation. We're unable to have a conversation prior to court today, hence his attire, but that will all be taken care of by the next.
Probable cause conference will be adjourned August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case People versus Jonathan Hughes.
Sherilyn Foster Tucker on behalf of Jonathan Hughes.
Jonathan Hughes.
And Your Honor, we are requesting an exam, both these matters.
In both cases,
Yes, Your Honor,
all discovery is complete.
to my knowledge.
Would the people have their witnesses available the 19th? Preliminary examination in these matters will be set August 19th, 2025, 9 a.m. That will be before. Okay. These will be set at 12 noon. And those are before me.
And Your Honor, if I may address bond,
Briefly,
Mr. Hughes is hoping to be released to treatment. Would that be something that Your Honor would consider if I'm able to submit a stipulated order to the court?
we submit a stipulated order as per my practice. I will sign that if he's gonna go, wants to go to inpatient.
I guess I won't say objection specifically, but we would be requesting a tracking tether if that was granted. However, Mr. Hughes did just set his cases for exam. And we've had issues in other matters where defendants have set their cases for exam and then go on to treatment and not been available.
I don't know of any of those. So sign an order. If it won't be stipulated to, submit the order. If you want tracking on it, put the tracking on it and I'll just sign off on it. If
Okay.
he's not here, he's not here.
Thank you, Your Honor.
Sound will continue. Court does call the case People versus Tamaron Jones.
Carolyn Foster Tucker on behalf of Mr. Jones, who is approaching.
Tamarion
Jones. Tamarion Jones.
Tamarion Jones, sorry.
We are requesting an exam in this matter,
Discovery is complete.
to my knowledge.
People have their witnesses available the 19th.
We will try our best, John.
Preliminary examination in person, August 19th, 2025, 9 a.m. That is before
Judge Moore.
Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor.
Oh, well, that's okay. He had bond violation with the new case. So there was a request.
Is a bond violation in this case?
Yes, the last time Mr. Jones appeared in court, apparently there was an incident either that day or the day right before that. And there's a new case, with the same victim that is authorized at a 14B. And, it is information from her that she is requesting a remand if possible. Based on
Who is requesting a remand?
the victim in this case, same one in the new case, which is Mr. Jones' mother.
Do you know anything about that?
Your Honor, I was made aware that there is a new case. I believe it's set for an arraignment or is being set for an arraignment in 14B. Mr. Jones does deny the allegations and
I don't have anything. What is the violation?
I emailed the court about it. It was apparently Mr. Jones went when there's a no-go to and a no contact order with his mother, went over there. Is it another NDOP? It's another.
Is there a police report? Guys, I have nothing.
I understand that, Your Honor. I did send it to the court.
To which court? Us?
Yes.
When?
I believe it's on July 18th. If Your Honor is willing to recall this at 3 o'clock on the motion docket.
Well, do you have a copy of the report, counsel?
yes, I was given a copy of it.
So everybody's got a copy but me.
Oh, July 25th, yes, July 22nd, rather. I got the response from the court.
You sent it to Ms. Weidling?
I did.
Resend it.
Sure will.
We don't. All right, well, here's what I'll do. I'll pass this matter briefly and then make a decision as to whether or not I'll hear it now or I'll hear it at 3 o'clock.
Thank you, Your Honor.
Okay, so sir, you must remain here in the courthouse. Understood? What?
Yes, sir.
Thank you. Keep on. You can hear us now, you think? Court recalls case, People versus Tariq Wilson. Mr. Wilson, hear us?
Huh?
Mr. Wilson, can you hear us, sir?
Yes.
Yes, okay, thank you. All right,
Your Honor, we'd like to request to adjourn this matter. We were unable to get a hold of Mr. Wilson prior to today.
probable cause conference in this matter will be adjourned August 28, 2025, 9 a.m. Continued.
Mr. Wilson will be in touch, okay?
Court calls case People versus Michael Hill. Krajewski, you want to talk to us or no?
I'm sorry, my phone just glitched out. James Fifelski appearing on behalf of Michael Hill. I'd like to request a preliminary exam and for the court to
Well,
consider.
you requesting an
release to
adjournment or
inpatient treatment.
preliminary exam?
Preliminary examination, Your Honor.
All discoveries complete?
To my knowledge, yes.
People have their witnesses available the 19th. Preliminary examination in person will be set August 19th, 2025. What time? 12 noon. That's before me.
And Your Honor, just for the record, Mr. Fidelski did file a motion saying that he wanted the lab in person. So
At a prelim?
that's what he filed a motion for some time ago. That he wanted the
I'll waive that objection for purposes of preliminary examination.
Thank you, like the court will indicate. All right, thank you. Bond will continue in this case.
Thank you, Your Honor.
Court calls case People versus Gregory Bell.
and for Douglas for the people.
Bell on behalf of Mr. Bell, Mr. Coaching and Podium. Good morning, Your Honor, Gregory Bell. Today's a date and time set for a probable cause conference. We have tendered a
plea form to Your Honor. We'll be entering a plea today. I also have an assigned advice of rights form.
I have a plea form that indicates that the defendant will be pleading. I don't have what his plea is going to be. I'm assuming it's guilty.
Yes, Judge.
Sir, are you having a problem hearing me?
I was a second ago, Your Honor. I just needed to lean in a little bit. I got bad ears. I'm a vet and I fired too many weapons when I was in the service.
Okay.
I just have a little trouble hearing. So usually if I lean forward, it helps.
Well, we've got some equipment that might help you. So why don't we try that? Okay.
Okay.
Sorry. What brand?
I was in the Army and the infantry.
Were you?
Yes, sir.
Fantastic. How many years you served?
A little over 3.5.
All right.
Is that better, sir?
Much better. Yes, Your Honor.
Yeah. Okay. So I have the plea form indicates the defendant will be pleading, is it guilty?
Yes, Judge.
Will be pleading guilty to failure to return rental property 200 to 1,000. That's a 1-year offense. And then upon his successful plea to that charge, count 1 would be dismissed. There further is an agreement that there would be no upfront jail, although I can't bind the sentencing judge to that, and a delayed sentence.
Yes, Judge.
Does Judge Washington do delayed sentences that way?
I'm not sure, Judge. We talked about prosecutors deferred with Mr. Banis, but I believe what's our part? Yes. I believe she does, Judge, but she does.
Under 7741, 7771, or does a delayed sentence, or does she do deferred sentence?
I know she does deferred.
Okay, but that's not what this form says.
I believe the prosecutor's deferred is under 7711, is it not?
Actually, technically no.
Technically no.
Right. What is the intent of the parties?
The intent basically is to have it, basically to earn the deferred sentence, to have it dismissed upon completion.
Then give me a right form.
Understood.
I'll call it back up.
Thank you, Judge.
All right, thank you. Or call these people versus Marcus Jones.
You're on ready to go for the people.
Marcus Jones, is this Marcus Lamar?
Are there 2 Marcus Jones?
I think so.
Yeah, that's right. Because we have 2 Torcio feasters.
I'd be shocked.
I did, we have 2 Torcio feasters. In fact, yesterday I called your name, expecting to see you. It was another Torcio feaster. It was incredible. He was bald too. Just so you know. That's what they do.
Is this Goku's name?
Okay, so let's make sure that I was informed we had 2 Marcus Joneses, one that does not have a middle initial and one that does. Do you have a middle name?
Yes, sir.
Okay, what's your middle name?
Deshaun.
Give me your date of birth.
0503-2004.
0503-2004.
Yes, Your Honor.
Okay, this case is him. What here, Marcus Jones? No, go.
I heard it in there.
No, I figured it out.
There are 2 Torcio
Course, 2 Torcio feasters. We got it all straight. I think the other feaster I locked up. Something went wrong. All right.
There actually are 2 Sam Bernstein, so.
There are, but we got lucky. Okay. So,
correct, Mr. Jones, we're hoping for an adjournment to obtain a review discovery, Your Honor.
All right.
Your Honor, people need to respond when appropriate.
Pardon?
People respond when appropriate.
Okay. I will adjourn this then to the 28th. Probable cause conference, August 28th, 2025, 9 a.m. As to bond.
Your Honor, the bond is currently set, I believe it's $10,000 cash or surety. People renewed their original request of $50,000.
Of how much?
$50,000 cash or surety. The underlying offense which charges an attempt armed robbery intent to submit an amended complaint of assault with intent to rob while armed, the more severe felony. The factual background here are concerns for public safety. When law enforcement did a search warrant of the defendant, the co-defendant's home, they found a stolen Glock handgun, 3 additional firearms, including parts and materials to convert a gun to be fully automatic. 2 of the additional firearms were stolen. 1 was not registered to anyone. Both this defendant and the co-defendant have prior weapons-related offenses under HIDA. So I'm concerned for the public safety. I think the $10,000 was an use of discretion, that $50,000.
Response.
Somewhat handicapped coming in because I'm jumping into this case recently. I only received discovery last night, so I haven't had a chance to review it. It sounds like the people intend to file a renewed complaint that changes the charges, and that's part of the basis of the request. I would ask if they are going to file such a complaint that could go along with a motion to address bond, and we could do that next week. And I could be more fully prepared to understand what the argument is.
There's a co-defendant in this case.
Yes, Your Honor.
What's that bond?
It's also said 10,000. I was going to make the same request on that case when it was called.
Is that one going to be amended also?
Yes, Your Honor.
Okay, so in that individual's in custody?
Yes.
So why don't I have an amended complaint now?
I have not had the opportunity to prepare that. I will follow the purpose.
And you don't have the discovery yet.
I did receive discovery last night, but I haven't had a chance to look at it yet.
Chance to go through it. So at this juncture, what I'm going to do with reference to this case and the other, I guess the co-defendant's case regarding bond is I'm going to deny the request without prejudice. You file your additional charges and then we can hear it at that point in time and give counsel an opportunity to see it.
Understood. Thank you, Your Honor.
So at this point, bond will continue.
Thank you, Your Honor.
Court does call the case People versus Jessica Hefner.
Good morning, Your Honor. Amy Reiser, appearing on behalf of People.
Tyler Brill on behalf of Jessica Hafner, who's approaching the podium. If you speak, Ms. Hafner, please introduce yourself to his honor.
Jessica Hafner.
Thank you.
Good morning, Judge. Thank you. We are here for probable cause conference. We are waiting on a few items of discovery still, which APA Reiser assures me is on the way. We are asking for a brief adjournment.
Would everything be settled regarding the other discovery and everything if I set this to the 28th? Or you need more time?
For an exam of purposes.
Yeah, I was going to set it for a PCC.
Yes, we're asking for an adjournment PCC.
Detective's working on the 911 call today, and I just received the lens, so I'll forward that.
Okay. Perfect.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continue.
Thank you.
Court calls case People versus Anthony Williams.
Morning, Your Honor. James McWheel, Special Assistant Attorney General on behalf of the people.
Assistant Public Defender Chelsea Virgils on behalf of Anthony Williams, who is in custody.
Anthony Williams.
Thank you.
Your Honor, we are asking for an adjournment, and when appropriate, we would ask to address bond.
Purpose of the adjournment.
Just to continue a plea discussion.
August 28th, 2025.
Mhm.
You said that the victim in this case is here?
Correct, Your Honor. Yes, she's here.
Mr. Attorney General, did you indicate to the victim or payee in this case or that she was supposed to be present at this hearing?
I don't believe anything specific, Your Honor, but naturally the victims are custodial parents are apprised of all court proceedings, so I
Right.
suspect she's there voluntarily.
Okay, all right, I didn't, okay. Well. Where is she? Is there something you wanted to tell the court, ma'am? It's a bit unusual at this particular point in the proceeding, but no, you just are here today. Okay, that's fine. Welcome. All right. All right. I just wanted to make sure I wasn't ignoring anybody. All right.
Regarding bond, Your Honor.
Yes, well, let me finish this. August 28, 2025, 9 a.m. for the probable cause conference. Yes, as to bond.
Thank you for that adjournment. Regarding bond, I understand there are rules about bond in these kinds of cases. However, we're asking the court to lower this to a personal bond if you would consider it. Mr. Williams is a hardworking man. He works full-time as a production supervisor, and that is important for him to continue making payments. We do have an order from the court, the circuit court, stating that income withholding began at the beginning of the year. So
beginning when?
At 2025, January 2025. So he wants to continue working so that he can continue making these payments.
What do you have as bond?
And I do have that order if the court would like it.
It's 2,500, 5,000 cash. That's the same.
But that's just an order of income withholding.
Yes, Your Honor.
Yeah, if I may, when the court's ready.
Yes.
Yeah, thank you, Judge. I saw that order also and found it fascinating that an income withholding order was supposed to start January of this year. We have not shown any payments in this case for 2 years, since August of 2023. So apparently there may be a violation of that first order. But the bottom line is, Your Honor, the statute clearly provides what the bond, a recommended bond should be. $2,500 cash in a case like this is not that excessive. As indicated, we see no indication of payment since August of 2023. So if he has been working, he certainly hasn't been paying his support. So we ask that the court continue the bond as currently set, Your Honor.
Your Honor, this is part of the reason for the adjournment. I'm not sure if there's a miscommunication, but I certainly intend to seek out further information regarding this. Mr. Williams strongly believes he's been seeing these payments coming out of his paycheck. He believes it's been 30% of his after-tax income. So we're seeking more information regarding that, and we ask the court to allow.
Yeah, but one could really see that clearly, particularly if it's been coming out since January. I mean, I could see maybe recent payments not showing up on the system, but from January, if he's been compliant with that income withholding order, those payments would have shown up. And then would have been transferred to the victim in the case, and so she would have received payment.
And I don't know that she hasn't. We just need some time to get more information regarding this. We're asking for him to do that.
Ma'am, we can find that. Have you received payments?
Not in January. I did receive a payment from him in the month of July, in the month of June.
June and July, you received payments.
Yes. I received a payment on July, most recently on Monday, July 28th.
Okay, I don't want to know the amount, but were those basically single payments, or was it a huge lump sum payment?
It was a payment of $400. I don't know if that was a single payment or lump sum.
How much is the income withholding order?
I don't believe it states a specific amount. I believe that his obligation is around that amount per month.
Around 400 per month?
I think it's
so. Pardon?
The information I have, Your Honor, is $950 a month in child support.
You said 900
950, right,
per month.
per month.
And so for at least one of the months, she's only received 400. So I don't know how he's in compliance with that order, and certainly would be in compliance with this one. I mean, if the payments were being received, then certainly that might, and for whatever reason, not credited. I don't know, but that doesn't sound like that's the case to me. So so I think that the bond is appropriately set, and irrespective of that, even if those payments that she's indicating are credited, he's still 8,000, well, he's still 9,000 in the hole. So I'm not going to change the bond. Motion for bond reduction in this matter will be denied.
Thank you, Your
Bond
Honor.
will continue. All right, thank you. Thank you, ma'am. I guess it's good you came down. Okay, I didn't have the answer, but you did. All right, thank you. Court does call the case of the people versus Riel Boyd.
Ally Zend on behalf of the people, Your Honor.
Ready, Your Honor. Robert J. Cole on behalf of Ms. Boyd is approaching the podium. Did you state your name here?
Riel Boyd.
Judge, in this matter, can we set this matter for exam?
Exam?
Yes, please.
Discovery is complete.
Yes, Your Honor.
Your Honor, it's, everything we have is given to Mr. Kilwell. He made me aware of something that he was looking for. I don't know if it exists or not, so I wouldn't. We're gonna reach out.
We're fine.
And if we should have it by exam if it exists.
We're good with
That
that.
was extraordinarily cryptic.
We don't want to upset Your Honor. We're ready.
I'm not, why do you think what are you gonna do, Kilowell?
We'd like to set it.
You're looking to upset.
Judge, you're a compassionate judge, you know that. And we just want to set it for exam.
I'll do that.
Thank you, Judge.
I'll indicate that discovery is complete. I don't know what you guys are doing. Would you have your witnesses available the 19th?
Yes, Your Honor.
Preliminary examination in person, August 19th, 2025, 9 a.m. That is before Judge Moore. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, Ms. Boyd. Court does call the case of the people versus Devontae Owens.
Andrew Schultz, gang on the people. Morning, Your Honor. Please, Honorable Court, Randy Bird on behalf of Devontae Owens. Mr. Owens, can you please state your full name for the record?
Devontae Lamar Owens.
Ron, I'm wondering if you can also call Ms. Adonis Sweat, their co-defendants.
Why is she yelling at me to call it? I'm not, there, he's in custody? I'm not bringing another person out. Mr. Childers did apprise us that they were co-defendants, but that they were requesting adjournment, so I don't know why they need to be called together.
Okay.
But thank you for interrupting.
Correct, Your Honor. I need an adjournment, please. I'm gonna at least need at least a month.
A month.
Maybe more.
September 11th, right?
September 11th is good.
Well, you don't know, but all right. Probable cause conference, September 11th, 2025, 9 a.m. Bond will continue. All right, thank you. Court does call the case People versus Philip Carrick.
Have a great day.
You do the same.
Ally Zend on behalf of the people, Your Honor.
Sam Bernstein with and on behalf of Mr. Carrick.
Philip Carrick.
You're requesting an adjournment.
Yes, Your Honor.
How much time did you need?
The August 28th date would work well. Your
Would
Honor.
work. Without objection, probable cause conference, August 28th, 2025. 9 a.m. Bond will continue. This is the one I received. I did not sign it.
You did not have a record. You should do that.
All right. Bond will continue. I received which seemed a bit strange given the bond argument that was made, as well as the tether. I received a stipulated order that the court was uncomfortable signing. Sure. We're clear. Bench conference on a stipulated order to modify the bond condition to allow the defendant to go to work. As I was indicating, given the argument that was being made and everything, it seemed a little bit odd to me. And I wasn't going to sign it until I got some clarification regarding it. But I think I have it. And the defendant has insisted because the bus route, which I didn't know I don't know what bus route is what, but he just explained that that's the bus that runs from basically outside of the courthouse down to the 777 building. So, all right, then I will sign that order. Let's see. All right. I got it. Okay, thank you, Honor.
Thank you.
Court does call the case People versus Hannah Smith Seeley.
APA Richard McDuffie for the people.
Your Honor, good morning. Joe Simon appearing by Zoom for Ms. Smith Seeley.
Oh, I'm sorry, Mr. Simon. Hi.
Hello, Your Honor. We switched the time and your staff was gracious enough to allow me to appear by Zoom so that I could make it.
Yes, sir. All right, what are we doing on this case?
Your Honor, the parties have reached a resolution of the case. You should have a plea form in front of you. However, there's a couple things to update the court on. That my client had a single instance of a scram tether violation. She's been on since May 27, 2025. On one date, that being July 12, 2025, she had numbers. Community Corrections asked my client to report everything she did that day because she insists she did not consume alcohol. The only thing that she could report was that the landlord had an industrial service, or not, I mean, a service come in and do carpet cleaning. She has a toddler that's 1 year old, a toddler that she plays with them on the floor. That's the only explanation she could offer. Community Corrections did not think that that was accurate, and that's how we're here. The people have, excuse me, my client was screened and accepted into the 15th District Court Sobriety Court. Ms. Johns of the Sobriety Court is aware of this violation. She will still take my client. My client still wants to go to Sobriety Court. And if we can resolve the plea today, as indicated on the plea form, by the way, I forgot to check the guilty box on that form. That's my error. I apologize. We asked the court to allow that to happen. And I told Ms. Johns that court runs on Fridays, as the court may know, the 15th District Court Sobriety Court. When I originally, this was on the 3 o'clock block, I told Ms. Johns that by the time my client, if your court released my client, that by the time she got tethered again, she would never be available for Friday. But now that we're on the 9 o'clock block, that could happen. And if the court allowed that privilege, I'll do what I can to make that work out.
So she would be appearing at the sobriety court tomorrow morning, you're indicating?
Well, she won't be officially accepted until there's a sentencing, but
right.
I'm sorry, that's not true. She's accepted, but she won't be a participant officially until she's sentenced. But I think Ms. Johns would want her there tomorrow if she was able to be there tomorrow, and my client would go tomorrow.
Okay. Any response from the people on that? All right. So I've checked the guilty box, also the sentencing judge waiver, because this is not my case, but I presume you went through that with her.
I
Mr.
did,
Simmons?
Your Honor.
All right. May I have her sworn?
Solemnly swear or affirm the testimony you're about to give the truth, whole truth, and nothing but the truth, so help you God.
Yes.
Lower your hand and say, and then spell your name.
Hannah Smith Sealy.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of operating with a high BAC second offense. Is that correct?
Yes, Your Honor.
All right. That's a misdemeanor punishable by up to a fine of $1,000, 5 days to 1 year in jail. The court could order community service and any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
I should also advise you that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before a judge. Hello.
More.
Who is my 15th district court judge?
Judge Moore does the sobriety court.
Judge Perry. Well, we have to do it by the numbers. This is a Perry case?
Yes.
All right. You'll be sentenced before Judge Perry in the 15th district court. You understand that, ma'am?
Yes, Your Honor.
All right. So to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
You have any questions regarding any of those rights?
No, Your Honor.
You'll see on the podium, I need you to look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
As soon as I can find my paperwork. On July 31st, 2024, at the location of Washtenaw Avenue near East Stadium Boulevard in the city of Ann Arbor, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
Do you recall what you had and how much?
I had a substantial amount, Your Honor.
Okay. Were you stopped by the police or was there an accident?
There was an accident.
What happened?
Your Honor, my client was badly injured. She doesn't really know. Her car struck a pole. That's really why she can't quantify the alcohol. You'll hear in a minute that the BAC by blood was 0.336.
So you know that you hit a pole. All right.
Yes.
But all right. So at some point, ma'am, you're not going to dispute you were taken to the hospital, correct?
Yes, Your Honor.
All right. And at that point, there was a blood test. You're also not disputing that.
No, Your Honor.
And you're not disputing the right of the police to take you to the hospital and have a blood test taken,
No.
correct?
Correct.
All right. And the result of that blood test, as your counsel has indicated, is 0.336.
Yes, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. Had you previously been convicted of operating while intoxicated on or about April 16, 2014 in the 14B District Court of operating while intoxicated and or operating while impaired on or about December 1st, 2022 in the 14B District?
Yes, Your Honor.
All right. Ma'am, I do have to advise you, because there at least is an agreement regarding sobriety court in this case, that if you were to commit misconduct between the time of my acceptance of your plea and the time of your sentencing, that first of all, you would not be permitted to withdraw your plea. And secondly, that any sentence evaluation or recommendation, the court would no longer be bound by. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
I know about the people.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. I'll set sentencing in this case, and you guys can work around what you'd like to work around, but sentencing,
Sentencing will be August 28th at 8:30 a.m.
August 28th, 2025, 8:30 before Judge Perry. That's the time that we have. With reference to bond, any response from the people?
Your Honor, I just want to make sure I'm clear. Counsel is requesting her to be released on PR bond in the hopes that she can be seen at 15th tomorrow.
No. No.
Well, he wants her bond reinstated.
Yes.
Which means she would have to go back on a tether. And then the hopes is that she'll be out. She would attend at least something regarding the sobriety court tomorrow. Although not officially participating.
Yeah, and I'm just going to try to make that happen. I can't guarantee that it will, but yes, she's already attended and observed, but I know that after this disposition, I will inform Ms. Johns, and if it can happen, I'm pretty confident she'll want her to observe again.
I understand, the people, quite frankly, don't buy the explanation regarding the reason for the scram tether violation. But I also understand that due to the circumstances of her transferring, we don't necessarily need to hold a whole hearing about it, essentially. So the people defer to the court. I am certainly requesting that her bond be reinstated with that scram tether.
Can I say something?
Pardon?
Can I say something?
Want to say something? Go ahead.
I still have the tether on.
You still have a tether on.
Yes.
I made a wrongful assumption. Well, that makes things a little bit easier. I'll notify Ms. Johns right away.
All right. What time is sobriety court?
He usually runs 8 a.m.
Defendant's motion, reinstate her previous bond. But that reinstatement of her previous bond will not take effect until 12:01 a.m. on 8/8/2025. Since she already has the tether on.
So, Your Honor, I'm just, if that means that she'll be held through 12:01 a.m. tomorrow, correct?
Correct. She
did.
can then get herself somehow down to Ann Arbor by 8 if she's going to attend that session.
Okay. That might be a little more difficult. We'll try to make that happen.
It shouldn't be difficult. She can walk to Ann Arbor by that time.
Thank you, Your Honor.
I know you could, and you're much older than she is.
Well, not at present, but thank you. Your Honor.
Okay. All right. Thank you. No, well, no, because I'm reinstating the tether. So we may need a new just tether order. So that they're clear. But she already has it on. Court calls the case People versus James Belleville.
Alex, on behalf of the people.
Good morning, Your Honor. Edward Drukas on behalf of James Belleville, who should be appearing on Zoom. Could you unmute Mr. Belleville?
Yeah, I'm unmuted. Okay, state your name, sir.
James Michael Belleville.
All right, go ahead.
Thank you, Your Honor. I'm asking for about a 3-week adjournment pursuant to what's in our green sheet.
Probable cause conference, August 28th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued.
Thank you, Your Honor.
Thank you, sir. Court calls the case of the people versus Sheena Stout.
Assistant Public Defender Chelsea Ridgeels with and on behalf of Sheena Stout.
Your name, ma'am?
Sheila F. Stout.
All right, what are we doing?
Your Honor, we are asking for an adjournment in this case. I'm also asking to briefly address bond.
We have a green sheet. Probable cause conference in this case will be adjourned to August 28th, 2025, 9 a.m. Yes, as to Bob.
Your Honor, Ms. Stout expressed to me desire to seek substance abuse treatment. I believe that the prosecution may stipulate to that. I can have a stipend order presented to the court later today. So we're just asking for the court to allow her release to inpatient treatment.
I will always allow release to inpatient treatment. Just send me the order. I'll sign off on it.
Okay, thank you, Your Honor.
Bond will continue. Thank you. Court calls the case, People versus Taylor Adams.
And Mac, on behalf of Mr. Adams, who is to my right, please state your name for the record.
Taylor Adams. I have a question, Your Honor, if that's okay.
You have a question
For you, if that's okay.
for me?
Yes. What are my charges on this case?
Yeah. What are they?
What are they? Yeah.
You don't recall them from arraignment or?
No, I just wanted, I just wanted to make sure. I was told that it was malicious. It's not attempted. And I want to make sure that it's attempted. That's what I was charged with was,
Okay.
legend.
You have two charges.
Yep.
That allege that on or about December 6, 2024, location of Sibley Road in Sylvan Township. Count one is attempted malicious destruction of fire or police property.
Attempted.
That's the 2-year offense.
Yep.
Then the second charge is reckless use of a firearm or weapon. That's a 90-day, $500 fine. Those are the two charges of that.
Already attempted. Thank you, Your Honor.
Thank you.
Your Honor, requesting to adjourn this matter.
Without objection, probable cause conference, August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thanks, sir.
Those people. Court does call the case of the People versus Adonis Sweat.
Hang on behalf of the people.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Adonis Sweat.
Adonis Sweat.
Okay. You would like the same adjournment to the 11th?
Yes, Judge, the prosecutor just informed me that there's more that he was made aware of yesterday, more discovery.
Probable cause conference will be adjourned September 11th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. The court does. Court does call the case of People versus Trayvon Addison.
We're going to read for the people.
And Mac, on behalf of Mr. Addison, who is approaching, please state your name for the record.
Trayvon Addison.
Your Honor, we request to set this matter for preliminary examination and all discovery is complete, as far as you're aware.
People have their witnesses available on the 19th.
We'll do our best, Your Honor. Thank you.
Preliminary examination in person, August 19th, 2025, 9 a.m. That is before Judge.
12 noon with you.
12 noon, that's before me. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Shaquille O'Neal Tubbs.
Good morning, I'm Rob Jekyll on behalf of Mr. Tubbs. Judge, in this matter,
State your name, please.
I'm sorry.
Shaquille O'Neal Tubbs. Thank you.
Sign this, okay, this is Judge, Mr. Ken Overwater from the PD office has him in recovery court. I talked to Ms. Sample. She says if we can waive him up to circuit court, he will be
He can
eligible for
get
the
that.
recovery court.
Okay.
Is that your signature and X? Okay. There's a waiver, Judge, properly signed,
I've
but
seen Mr. Tubbs for I don't know how long. I'll tell you if it's his. Yep, that's it. Sir, you're waiving your right to a preliminary examination. Yes, sir. You understand a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it. Yes, sir. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution. Yes, sir. All right, people also waive their right. Preliminary examination haven't been waived, defendants found over on the single count.
as far as the information, Judge, will waive its reading. My client would stand mute.
Defendant able to waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
August 21st at 1:30 with Judge Slay.
August 21st, 2025, 1:30 before Judge Slay.
We'll probably be in recovery court.
Oh,
yes. Okay, hold on. We're gonna gotta go over, get to recovery court.
Okay.
Okay, all right, thanks.
Bond will continue. Good luck, Mr. Tubbs. Court calls case People versus Seth Anderson.
Good morning again, Your Honor. Assistant Public Defender Davi Leba on behalf of Mr. Anderson, who's approaching. Mr. Anderson, can you state your name, sir?
Seth Anderson.
And Your Honor, today we're going to be requesting an adjournment. We've discussed a potential offer to the prosecutor. They've indicated that they'd need some more time to decide on that, and my client's indicated he'd like some time to consider that as well.
August 28, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case People versus Sean Belledew.
If you were to look for people,
Edward Ricks on behalf of Sean Billady.
Name, sir? I have before me two plea forms. Is that what we're doing today?
Yes, Your Honor.
They both indicate that in each case, he'll be pleading to an added count two of larceny, 200 to 1,000. He'll be pleading no contest needs. The 1-year offenses upon a successful plea to that charge count, one would be dismissed. There is no other.
That's our understanding.
It's the court's full understanding. Is that the people's understanding?
that's where we're going.
May I have him sworn?
Raise your right hand. Solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so you got. Lower your hand and then state your name.
Sean Moore Proctor.
All right. Sir, it is his court's understanding that you're going to be pleading guilty to, or no contest to, two charges of larceny, 200 to 1,000. Those are misdemeanors, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is subject matter to theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in these cases, and you would be sentenced before Judge.
Yes, Your Honor.
Before Judge Valvo and Perry. Which one's Valvo? Do you understand what a no contest plea is, sir?
Yes, sir.
All right. Two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand these charges?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. So, sir, to the charge of larceny 200 to 1,000 contained in the case ending in 5670. He's already signed sentencing, Judge waivers. I don't need them.
Yes, Your Honor.
Just trying to get the offense date on this. I have my they filed. Get these files this way. In 5670 occurring on July 10th, 2024. How do you plead?
No contest.
To that same charge contained in the case 5615 occurring. Crazy. I'm sorry, sir. I don't know why they have this file done in this way. Really? Where's my complaint? You have an offense back. June 5th. Occurring on June 5th, 2025. How do you plead?
No contest, Your Honor. Contest?
You understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form in each of these cases?
Yes.
You have any questions regarding any of those rights?
No, Your Honor.
Look on the podium, you'll see a copy of one. Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Nope.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Yes, Your Honor.
And because, well, I won't ask that part. The court has been provided and has reviewed in the case ending 5670, University of Michigan Department of Public Safety report for their case number 2490305419. And in the other matter, Ann Arbor Police Department report for their case number 2431255. Any objection to the court having reviewed those reports?
No, Your Honor. No, Your Honor.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel? Well,
civil
before I do that, sir, I do have to advise you that if between the time of my acceptance of your plea and your sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea. I also need to advise you that any sentence agreement, evaluation, or recommendation, the court would no longer be bound by. You understand that?
Yes, sir.
You do?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have caused this plea?
No, Your Honor.
All right. And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Your Honor, it's a no contest plea for civil liability. I don't think.
Thank you. Okay. All right. I did not ask.
Yes, Your Honor, people are satisfied.
Defense is now satisfied.
Court will accept the defendant's no contest pleas to count 2 in both of these cases. Count 1 is dismissed. You're going to get 2 sentencing dates and you're going to have to reconcile them. Pre-sentence investigation and reports are ordered at 15th District Court. In case 5670, sentencing will occur
August 26th at 9 a.m.
August 26, 2025, 9 a.m. before Judge Valvo. In the other matter, sentencing will occur
August 28th at 8:30 a.m.
August 28th, 2025, 8:30 a.m. That is before Judge Perry. Bond in each of these cases will continue.
Thank you, Your Honor.
those. I don't know why he can have those back. I don't need the extra paper.
Thank you.
You all right? You okay? Court calls the case, People versus Anitha Barnes.
Maybe we're just different people.
Anitha Barnes.
Can't find a feaster when you need him. Really, you sat here all morning and called your case and you weren't here. What are you?
I had to go eat some apple, Judge.
What?
Sorry, Judge. I wanted to take my breakfast. My apologies.
Seriously?
I apologize, Judge. I don't know.
Go ahead.
I am here.
Ma'am, could you please state your name? Because
Anitha Barnes.
thank you. Because
Thank you, Judge.
features a mess. Anyway,
You should have a green sheet in your
I
file,
do.
Your Honor. Ms. Barnes and I were unable to connect. I know we're trying to get this matter resolved. Hopefully she'll be able to give us a call before the next pretrial date, PCC date, and we can hopefully get this matter moved forward.
probable cause conference, August 28th, 2025, 9 a.m. Bond will continue. All right. Thank you, Ms. Barnes.
Thank you, Judge. Sorry again.
No. Enjoy that apple.
I'll wait for my apple.
No, go, please eat it. There's nothing like looking at a half-eaten apple that like makes my day just go forward. Go ahead, finish your breakfast.
I'll be right there.
All right, we know where to find you. Court calls the case, People versus Savannah Crittenden. Crittenden.
Good morning, Your Honor. James Fifelski, standing in for Attorney Robert Elman on behalf of Ms. Crittenden.
Andrew Childress, attorney on behalf of People.
Ma'am, you have any objection to Mr. Fifelski standing in for your counsel of record?
I don't, Your Honor.
All right, very good. What are we doing?
Your Honor, we are asking the court to set this for preliminary examination.
Discovery, to your knowledge, is complete.
Yes, Your Honor.
People have their witnesses available the 19th. Preliminary examination in person, August 19th, 2025, 9 a.m. That is before Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of People versus Roderick Bates.
Douglas to the people.
Serious?
What a judge.
You didn't even finish the apple.
I'm working on it.
What?
Like 4 more bites taken out of it.
Smile.
Working on it.
You got like small teeth or something.
I
You
do.
should have been done with that, right? Shanaz?
You must have chewed
You know,
like,
he should have been done.
isn't it like 20 times for each bite or something?
I
Take
don't
some
know.
time.
I don't know how to eat that apple, but it's still here.
Torsia Feaster, some public defender, on behalf of, but apparently not with, Mr. Bates. We did try to reach out to Mr. Bates by email and by phone. We did not receive any response. For the record, I would request an adjournment, but I have no idea where Mr. Bates is.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
Thank you.
I'll try to get it.
Yeah, go finish. That's a joke. Let's call it feaster. No. Court, Fleischer. Okay. The court calls the case of the People versus Ryan Carter Price.
If you were to people.
And Assistant Public Defender, Shanaz Carey, Your Honor, on behalf of Mr. Ryan Carter Price, who's approaching. Mr. Carter Price, state your name for the record, please.
Ryan Carter Price.
Thank you.
Judge, we're asking that this matter be set for preliminary examination.
Discovery is complete.
To our knowledge, Your Honor.
People have their witnesses available the 19th. Preliminary examination in person, August 19th, 2025. Time. 12 noon, that is before me.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case of People versus April Black.
Stephanie Cannon on behalf of Ms. Black.
Oh, wow. Where have you been? Where have you been? That's my way of saying I missed you. Not really. Don't get all sappy. We just missed you because it was quiet.
I've been good, Your Honor.
Okay.
Well, trying. Your Honor, we're just asking for a brief adjournment in this matter. I have mitigation information we're hoping to use to resolve this short of trial.
Probable cause conference will be adjourned August 28, 2025, 9 a.m. Bond continue. Thank you, ma'am.
Thank you so much, Your Honor. And I find that picture.
Court calls case People versus J. Dingman.
Assistant Public Defender Chelsea Virgils with and on behalf of Jay Dingman who approaches. Mr. Dingman, please state your name.
J. Juan Dingman.
Yes, I'm here for referral to treatment court. Your Honor, we're asking for an adjournment today for referral to mental health treatment court and ask the court to sign the referral form. I would also ask to address bond when appropriate.
Of course you would. Do we know how long they're operating before they do anything and make their assessment?
I don't know, Your Honor. In my experience, it's been a couple weeks, but I don't know for sure.
Yeah, okay, well, let's at least give it a shot so you can just sit there out. Pardon? 3 weeks. All right. I'll then adjourn this out to August 28, 2025, 9 a.m. as to bond.
Your Honor, we are asking you to consider a personal bond today. He does have a permanent address in Ypsilanti. He has the support of CMH, who he's been working with long-term, as well as his family. He asks to await his decision about treatment court out of custody, if you would consider that.
All right. Response from people.
Your Honor, we do not think that would best for Mr. Dingman. He did fail to appear at his last court date. We should note that reason believe that the health court may be appropriate for Mr. Dingman is because he does struggle with mental health issues. He has been with long term, but we know that despite that, he still has picked up this case, which we do think the description has a lot to do with his health status. So, Your Honor, we do not think that Mr. Dingman on his own is able to procure when required to do so. So I think that if he was just released, we wouldn't see him until we don't know what time. So, Your Honor, I would object to release on a personal bond unless it was with a covenant to inpatient treatment.
Right, but there's not been a request for inpatient treatment. Certainly, I would consider that if that were what was being asked, but I don't think that's what's being asked of the court. The motion for bond modification and or reduction is denied. The defendant already has a record of failing to appear before the court. His bond will continue as set. Thank you.
Thank you, Your Honor.
Court does call the case People versus Daniel Bowe.
The people.
Good morning, Your Honor. Assistant Public Defender Alexis Zerps on behalf of Mr. Bowe. Mr. Bowe, can you please state your name for the record?
Daniel Bowe.
I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
All right, the plea form indicates that defendant will be pleading no contest to the charge of retail fraud in second degree, the 1-year offense upon the successful plea to that charge. Count 1 would be dismissed. There is also the agreement of restitution and, well, it says the amount of no dollars.
That's correct, Your Honor. There's no restitution necessary for this case.
So why is it on here? Anyway, never mind. All right. I have him sworn.
Do you solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so you got?
Yes, ma'am.
Lower your hand and then state.
Daniel Bow, DANIELBOW.
All right. Sir, it is this court's understanding you're going to plead guilty to, or plead no contest to the charge retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property stolen. If that's greater than $2,000, that would be the maximum fine. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Correct.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Correct.
And you also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Fleischer in the 14A3 District Court. You understand that?
Yes, Your Honor.
Basis for the no contest plea.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
Guilty. Or no contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
You almost blew it.
I know.
All right. You don't have any.
I don't get sleep at night. I got a newborn at home, so my mind's everywhere.
You got a newborn at home?
Yes, sir. Yeah.
Okay, we'll get to that. Is that your first one?
No, it's my second. My other one's 15.
Then that's old school for you then. All right. You signed an advice of rights form. No questions regarding those rights?
Correct, sir.
So look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of that form.
Yes, sir.
You understand you're giving up your right to appeal upright.
Correct.
Are you on probation or parole?
Yes.
But he was not at the time.
Oh, no.
Not at the time of the offense.
No.
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily?
Correct.
Of your own free will?
Yes, sir.
And because you believe that you are, well, I won't ask you before you get your guilty. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 249721. Any objection to the court having reviewed that report?
No objection, Your Honor.
Court, upon a review of that report, does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if I do accept your plea, and if between the time of this acceptance of the plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence recommendation if there were any in this case or evaluation, and you would not be entitled to withdraw your plea. You understand that, sir?
Correct, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have caused this plea?
None from people.
None from defense, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
October 6th at 9 a.m.
October 6, 2025, 9 a.m. That is before Judge Fleischer. Bond will continue. Congratulations, young man. Boy or girl?
Boy.
Boy?
Yeah, he just don't sleep at night. He's an angel during the day, but when it comes to nighttime.
That's how you got in trouble. So the apple doesn't fall far from the tree. All right. You take care, young man.
Thank you, Your Honor.
Court calls the case, People versus Cedric Green.
Ready, Judge?
Wow.
Court shall please the Assistant Public Defender on behalf of Mr. Green. Mr. Green, please state your name for the record.
Good morning, Cedric Green. Thank you. No apple?
I
You-
finished.
Did you finish?
I did finish it.
Took you long enough. All right.
Slow eater, sorry.
What are you doing?
Mr. Green has asked that I set this matter for preliminary examination. I believe all discovery is complete.
And when people have their witnesses available the 19th,
Yes, Your Honor.
preliminary examination in this matter will be set August 19th, 2025. Set at 9 a.m. before Judge Moore.
Thank you very much, Judge.
Bond continued. Thank you. Court does call the case of the people versus Zaria Brand.
Ally Zend on behalf of the people, Your Honor.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender with and on behalf of Zaria, I'm sorry,
Told you.
Zaria Brand.
Your name, ma'am?
Zaria Brand.
Zaria.
Your Honor, we do have a resolution. There's one outstanding issue that I just asked Ms. Zenda about a few minutes ago. So we have the paperwork, but we're going to look into that one issue. So I am asking for a brief adjournment. I think 2 weeks would be correct.
Probable cause conference, August 19th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor.
Court calls the case people versus Khalil Haddon.
People.
Assistant Public Defender Alexis Zerps with and on behalf of Mr. Haddon, who's approaching. Can you state your name for the record, Mr. Haddon?
Kahil Jabron Haddon.
Thank you.
Your Honor, we're requesting an adjournment for some further discussions.
Requesting an adjournment.
Yes, Your Honor.
Probable cause conference without objection, August 19th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case people versus Jamie Burke.
If you were to move the first people.
Matthew Mansour, Assistant Public Defender, on behalf of Mr. Jamie Burke. Jamie, can you please state your name for the judge?
Of course. Good morning, Your Honor. Jamie Burke here.
Thank you.
Of course.
Your Honor, we're going to be requesting an adjournment, please, to satisfy the restitution amount, and
how long is that going to take him?
The longer the better, Your Honor, but I'll leave it up to your discretion. Maybe.
Currently, I'm doing Uber, word of mouth Uber, and
okay.
And then doing trades with electronics to like pawn shops and things like that, buying them from. So I'm getting money slowly, and I just applied to a hotel this morning as well. So
we'll take a month, Your Honor, if you could.
If I can. So I can at least get the funds up, if I may, Your Honor.
Is he going to be able to do it in a month?
Absolutely.
Probable cause conference will be adjourned September 11th, 2025, 9 a.m. Bond continued. Thank you.
Thank you very much, Your Honor. I really appreciate that.
You're welcome.
I hope you have a wonderful day.
You do the same.
Thank you.
Court calls the case people versus, is it Jervapko Hitana? Ms. Willingbring, who I guess was the prosecutor. Oh, okay.
Assistant Public Defender Chelsea Virgil is with and on behalf of Zdravko Kitinov. Can you state your name?
Yes, sure. Good to know.
All right.
Your Honor, today, my client would like to waive his right to I'm sorry, can you sign right here? His right to a preliminary exam.
have discussed a few with that lower nail, as the first creature enter that plea agreement, we would not be remanding for the preliminary examination.
Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
Is that what you're doing, sir?
The plea agreement is on the table, I believe, still.
Yes, that's
Oh,
what she said. that-
Okay,
Yes, Your Honor.
plea agreement to obviously some felony charges that would take place in circuit court.
Yes,
So to accomplish that, are you waiving your right to a preliminary examination?
yes, I'd like to take the plea agreement.
Pardon? Okay, well, I have to make sure that you understand that a preliminary examination is a proceeding where the people would have to show by a standard of probable cause that the offenses alleged were committed and that you committed them. You understand that?
Yes, Your Honor.
All right. My understanding is that you're waiving or giving up that right to have that hearing and proceeding to circuit court for further resolution, which may include a plea agreement.
Yes, Your Honor.
All right. Is that your understanding?
Yes, my goal is to take the plea agreement. So, yes.
All right. But you understand you'll not have a preliminary examination. I just want to be clear on that.
I understand.
All right. The people have indicated they also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all 5 counts. Your turn.
But it cannot be taken.
We would acknowledge receipt, I'm sorry. I was momentarily distracted. I apologize, Your Honor. We would acknowledge receipt of the information, waive its formal reading and stand mute.
Defendant has waived formal reading, standing mute. Court will enter not guilty plea as to all counts. Pretrial in this matter will be set for
August 26th at 1:30 with Judge Combs.
August 26, 2025, 1:30, Judge Funky.
Thank you, Your Honor. If I may approach to sign the following information.
Yes, we'll bring that over to you. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case, People versus Bradley Chavez.
Andrew Childers, on behalf of the people.
Matthew Mansour, Assistant Public Defender, on behalf of Mr. Bradley Chavez, who should be appearing by Zoom. Bradley, can you please state your name for the judge?
Bradley Chavez.
I have before me a plea form. Is that what we're doing?
That's correct, Your Honor.
Plea form indicates that the defendant will be pleading guilty to an added count to use of methamphetamine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There is also no objection to seeking 7411. That's the court's full understanding of the agreement.
That's correct.
That is correct, Your Honor. Thank you.
All right. Chavez, could you please raise your right hand?
Yes, Your Honor.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. State your name again for the record.
My name is Bradley Chavez.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
And you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, I do.
Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
I plead guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, I do.
All right. You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. you understand that you're waiving those rights as well as other rights on that form?
Yes, I understand.
You understand you're giving up your right to appeal of right.
Yes, I do.
Are you on probation or parole?
Yes, I am.
All right, were you on probation at the time of this offense?
Yes, I was on probation during the time of the offense, and I was actually this was brought up in that court case. So I did have to turn myself in and serve time for that offense for violating. That was back in December, so that court is aware of that violation, and I did do time for that.
Okay, well, thank you for all of the information. I do also have to advise you that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, Your Honor.
And you still wish to plead guilty to this charge?
Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of July 26, 2024, at the location of State Street near Dewey, City of Ann Arbor, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
Did you know what you were using was methamphetamine?
Yes, Your Honor.
Counsel, sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing in this matter, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and any sentence recommendation or evaluation, the court would no longer be bound by. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor, thank you.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea of guilt?
Defense satisfied as well, Your Honor, thank you.
Court will accept the defendant's plea of guilty to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be September 12, 2025, 8:30 before Judge Perry. Bond continues.
Thanks, Your Honor.
Thank you.
Do I have to check? My bad. I was gonna say, do I just have to check in with the 15th District Probation Department now?
Yes, sir.
Okay, all right, that's all I want to know. Thank you, Your Honor.
Thank you. Have a good day.
You too.
Court calls case People versus Kristen Knight.
That goes for the people.
Stephanie Can on behalf of Mr. Knight, who is approaching. Mr. Knight, when you are at the lectern, please state your name.
Christian Knight.
Thank you.
And Your Honor, at this time, we are going to ask for a preliminary exam.
All discovery is complete.
Yes, Your Honor, to my knowledge.
And would the people have their witnesses available the 19th?
Your Honor, we will do our best.
Preliminary examination in person, August 19th, 2025. 9 a.m., that is before, is it 9 a.m.? 12 noon, that's before me.
Thank you so much, Your Honor.
Thank you. Bond continues.
Oh.
Court calls case People versus Deshaun Clifton.
That goes for the people.
And Stephanie Can on behalf of Mr. Clifton, who is approaching, Your Honor. State your name, Mr. Clifton.
Sean Clifton.
And Your Honor, we are negotiating on this. We've been back and forth. We're just asking for some additional time to see if we can reach a resolution short of a preliminary exam.
August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Derek Coleman.
Alexander on behalf of the people, Your Honor. Assistant Public Defender Alexis Zerbs on behalf of Mr. Coleman, who's approaching.
Your name, sir?
Derek Coleman.
Thank you.
Your Honor, we respectfully request that this be set for preliminary exam.
Discovery is complete.
To my knowledge, yes.
Preliminary examination in person will be set August 19th, 2025. That's 9 a.m. before Judge Moore. People would have their witnesses available. I should. All right, thank you. Bond will continue.
Thank you, Your Honor.
Court does call the cases of the people versus Jacqueline Murray.
Andrew Chillis, appearing on behalf of the people.
Matthew Mansour, Assistant Public Defender, on behalf of Miss Jacqueline Murray. Jacqueline, can you state your name for the judge when you're ready?
Jacqueline Murray.
Hey, what are we doing?
Your Honor, there should be a plea form, 2 of them in there. We have a resolution.
Yes.
Both on the, what would be the 15th district court files.
Yes.
Based on the court's acceptance of the plea on those that people would file an ollie cross on the 14th.
Thank you. All right, very good. All right. And they are both, the defendant's going to be pleading to count, well, in the case ending in 5597, it would be count 3 of use of fentanyl, with counts 1 and 2 being dismissed. And in the other matter, it would be count 2 of use of fentanyl, with count 1 being dismissed, as well as the case ending in 622. Both of those 1 years. That's the court's full understanding of the.
Perfect, Your Honor.
May I have her sworn?
Solemnly swear or affirm testimony you're about to give whole truth and nothing but the truth that you got. Yes. Blow your. Say your name.
Jacqueline Murray.
All right. Ms. Murray, it's this court's understanding that you're going to plead to 2 charges of use of fentanyl. Those are misdemeanors punishable by up to 1 year incarceration or $1,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo and Judge Perry, respectively, in the 15th District Court. You understand that? All right. And understanding that, you still wish to plead to these charges?
Yes, Your Honor.
All right. So to the charge of use of fentanyl contained in the case ending 5597 with an offense date of June 22nd, 2023, how do you plead?
Guilty.
To that same charge contained in the case ending in 5540 with an offense date of October 6, 2022, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yep. Yes.
and because you believe that you are indeed guilty of this offense, of these
Yeah.
offenses.
Yes, Your Honor.
Starting first with the case ending in 5597. Ma'am, on the date of June 22nd, 2023, at the location of Warden Avenue near Dexter Avenue, City of Ann Arbor, Washtenaw County, State of Michigan, did you have fentanyl in your possession?
Yes, I did.
Had you used it?
Yes,
Did you know what you were using was fentanyl?
yes.
All right. Going to the next one. on the date of October 6, 2022, at the location of 727 Miller Avenue, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have fentanyl in your possession?
Yes, Your Honor.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
Yes, Your Honor.
All right. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and your time of sentencing, that if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea, as well as any sentence agreement or evaluation the court would not be bound by. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any promises, threats, or other inducements which have led to this plea?
None on the defense, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's pleas?
Defense is satisfied, Your Honor. Thank you.
All right. In the case ending in 5597, court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. I'll just finish up on that case. A pre-sentence investigation and report is ordered at 50 District Court. Sentencing in that case will be
August 28th at 8:30 with Judge Perry.
August 28, 2025, 8:30 before Judge Perry. Bond in that case will continue. In the other matter, the court will accept the defendant's plea guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15 District Court probation. Sentencing in that case will be
August 26th at 9 a.m. with Judge Valvo.
August 26, 2025, 9 a.m. before Judge Valvo. Bond in that case will continue. And the case ending in 25 or case ending or in 0622 as referenced on the plea form, that case is dismissed. All right. Thank you. Court calls case People versus Jermaine Dalton.
Ally's on behalf of the people, Your Honor.
Assistant Public Defender Dobby Leba on behalf of Mr. Dalton. Dalton, could you state your name, sir?
Jermaine Dalton.
And Your Honor, we're requesting an adjournment today. Mr. Dalton indicated to me he'd like to seek private counsel.
You what?
He would like to seek private counsel.
And pants.
Oh, I'm sorry, Your Honor. Do apologize.
I believe he'll be seeking both.
How much time does he need to do that?
How much time do you need, sir?
Honestly, could I have 3 weeks?
Your Honor, would the court be willing to do 30 days in this matter?
The only time I'll grant an adjournment for these purposes for you to see private counsel, private cause conference will be adjourned September 4th.
Thank you, Your Honor.
Thank you, Your Honor.
2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Do you have a green sheet?
Yes, Your Honor. Oh, apologies, I kept it in my hand.
Case People versus LaDonta Skinner.
If they were to the people.
Assistant Public Defender Dobby Leba for Mr. Skinner. Mr. Skinner, could you state your name, sir?
LaDonta Skinner.
Hey, what are we doing?
We're going to be requesting an adjournment in order to receive some additional discovery as well as look into some additional matters.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls case People versus Curtis Damon.
If they were to the people.
Apologies, Your Honor. Lori Yagis, Public Defender. On behalf, but not with Mr. Damon, Your Honor, may I, or may we approach?
Yes.
Sorry.
Yes. Yeah, on this one. Yes. Right. A bench warrant will issue for defendant's failure to appear. This matter. Court will indicate that given all of the circumstances in this case, I'm gonna set no bond. Get him here. See what we can do. That warrant will issue immediately. Okay, thank you. Court does call the case People versus Anthony Turner.
If you recommend that, good people.
Stephanie Tanner, we have, would you please report your name?
Anthony Turner.
All right. Turner, it's this court's understanding that he is going to plead to an added count 2, guilty of attempted unlawful use of a motor vehicle.
Yes, Your Honor, that's my understanding.
That's correct.
That's a 1-year offense. Well, I don't understand this form. Why do I have 2 penalties and 2 charges?
Your Honor, I'm sorry, go ahead. The count comes with a mandatory notice that the sentencing court could opt to sentence him to a 90-day offense, but we can't actually have a plea under that. It's just the sentencing notice, and we're required to listen.
The statute was amended, I think, last year.
No, I got what the statute is. I'm just, the way this is laid out here is this, okay. All right, so you're gonna plead to attempted motor vehicle unlawful use. That is a misdemeanor punishable by up to 1 year incarceration or $750 fine plus court costs, and that's an attempt. Do you understand that, sir?
Yes.
The court could also sentence you to a 90-day sentence or a $500 fine for plus court costs. You understand that?
Yes.
And you understand, sir, that upon your successful plea to that charge, count 1 would be dismissed.
Yes.
All right, I haven't had him sworn in. Let's have him sworn.
You raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you.
Lower your hand and then say your name.
Anthony Turner.
All right. And sir, you do understand what I indicated in terms of what you're going to be pleading to in the maximum penalties?
Yes.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
I understand.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of the trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
April 2nd, 2024, at the location of 508 Pearl Street, City of Ypsilanti, Washtenaw County, State of Michigan, What'd you try to do or do regarding a Jeep Wrangler that makes you think that you're guilty?
Well, it was parked in my driveway the night before and the doors were open. The keys were on the seat and I just took off with it the next morning. It was left there overnight and I took off with it the next morning.
You were gonna bring it back though, correct?
Yeah, I was. It was at my residence and it was just parked in my driveway. I had every intention on bringing
So the doors were open, keys were in it. You just took off for a ride, you were gonna bring it back.
Yeah, well, I have a condition and I just thought that like a moment without strenuous exercise would be like sufficient enough for myself. I have glass in my esophagus.
Got it. Okay.
And I wanted to go and get breakfast.
Oh, okay. So now I see. So you were attempting to leave, but you were gonna bring it back. Did you bring it back?
Yes, sir, I did.
Okay, but you didn't have permission of the owner of that vehicle or the person who had proper custody of the vehicle to use that vehicle?
No.
All right. All right, I think I got everything. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, that if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
I understand.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Your Honor, I wouldn't consider it that, but he is being admitted to the mental health treatment court, so I guess I would just add that for record.
He's being what?
Admitted to the mental health treatment court.
And I believe the court has the paperwork on that as well, Your Honor.
Is that part of this agreement?
It's not really part of the agreement, but I just.
Your Honor, we did that outside of that. He actually asked me about mental health court and like the second time I visited with him. So he was already referred and put into it by the time the plea. So I don't believe the plea is contingent on it, but he is voluntarily participating in mental health court.
Sure.
Got it. Okay. All right, very good. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
The people are satisfied.
You have, Your Honor.
Court will accept the defendant's plea to count 2, count 1 is dismissed.
Your Honor, can we address bond?
Sure.
Your Honor, my client has actually done at least 1 or 2 of the mental health court sessions already. Is that correct, Mr. Turner?
Yes.
He is asking to be released. He has the paperwork regarding who he needs to contact in mental health court. Can he be released prior to sentencing?
Is this the only thing holding him?
Yes, Your Honor.
Any response from the people?
In the court's discretion.
You don't have a distinction between in custody and out custody dates, or you just have one?
No, I have.
You got it.
Gotta come back.
Pre-sentence investigation and report is ordered. I will. Bond will be reduced. $5,000 personal cognizance bond with other conditions remaining in effect. So an out of sentence custody date would be sentencing date.
August 27th at 10 a.m.
August 27th, 2025, 10 a.m. before Judge Barr. All right, Mr. Turner?
Yes, sir.
Taking a chance on you, you better show up.
I got you, man.
You got it?
I got you.
Okay. If you don't show up, I gotta come out and find you myself.
All right.
You don't want me rolling up on you, do you?
No, sir.
All right, you're good. All right, take care. Court calls the case, People versus Cartier Drains.
Or Yaki, Assistant Public Defender. Your Honor, may we approach?
Really?
Yes, Your Honor.
Come on. Why? All right, the defendant is not here. We've had a bench conference case. I had, so that the record is clear, I specifically directed that this individual appear in person. Counsel indicates to me that she's been in contact with him. He, for whatever reason, can't find a ride. Maybe should have thought about that before he started acting the way he did. But notwithstanding that, I'll issue the bench warrant. Bond is set in the amount of $25,000 cash surety. I will not issue that warrant until the 14th of August.
Thank you, Your Honor.
Ms. Douglas, she was telling me about how to take care of hair. She was, she was explaining. Tell her I don't have any, but I knew. Court calls the case, People versus Johnny Walker.
Brian Bowling on behalf of Mr. Walker, Your Honor.
Julie Walker.
All right, Judge, I'm asking for an adjournment. We need some discovery in this matter, specifically video, which I think we should hopefully have before the next PCC. And then I was just hoping to address a bond when you're ready.
Right. Well, we kind of addressed it yesterday. And he has permission to leave. This is a veterans treatment type of program.
That's my understanding, Judge, correct?
Yeah. Oh, that's right. Okay, so here's our problem. I agreed to that yesterday so that he could get out in treatment. It sounded like a good program for him out in California. Problem is that when I signed the order in that case, the jail then informed me he has 3 FOC holds out of Muskegon.
There was an email sent this morning. Did you see that email? That Muskegon said they were not coming to get him on the FOC, and it was an advise and release. I know.
You have that?
Court staff was, I can approach if you'd like me to. I can pull it up on my phone.
Because the last indication we got was that they verbally told us Muskegon was coming to get him.
Fair enough. Ms. Perrine forwarded the email to me this morning, Your Honor. I believe the court had been CC'd on it, so I didn't print out a copy, but.
That's okay. Here's my position. I don't have a problem signing off on for him to go. My position hasn't changed on it. The problem was going to be that he wouldn't have gone to California for treatment. He would have gone to Muskegon.
Yeah, and that doesn't seem to be.
People have been lost there for years. No, I'm kidding.
That's submarine.
Muskegon's agreed. So they're unable to pick him up. Okay, so they won't come down and get you. This is virtually identical order to the other one.
Yeah, my order was the stipend order I submitted this morning, Judge, was just, he has a personal bond already in the felony case. So it was just to give him the ability to leave the state of Michigan.
Leave the state, got it. Okay, just in order consistent with that, got it. Okay, that's fantastic on that. Then what I'll do, I'll adjourn this. Remind me, Mr. Walker, remind my staff as to what we adjourned your other case to.
September,
September,
specific date.
I can't remember specific date.
Was 17th, right? Because we were gonna let you get out there. Hopefully you can get on Zoom and then we could continue on with the proceedings. Now I remember. So why don't I just put this the date after? I'll adjourn this to the 18th. 9 a.m. bond will.
Okay, time, okay. Yeah. That's gonna be 6 a.m. Check out.
His fiance is in here.
She was, Judge.
Was she?
Earlier, yeah.
She waited all day yesterday for her to get out. She must like you or something. I don't know.
Thank you.
You're welcome. Court calls case People versus Dustin Duncan.
And Lori Yagi, Assistant Public Defender with and on behalf of Mr. Duncan. Mr. Duncan, can you unmute yourself and say your name for the court?
Oh, there we go. Dustin Duncan. And I see hollow Michigan.
She needed to be able to hear you better.
Why is she out?
She's writing down every word you say.
But see, it's
Right,
like,
Kristen?
why, you look at together.
Mhm.
That's,
Are you trying to text him?
I am. Sorry, Your Honor. I know he was there.
yeah.
I apologize.
No, you don't.
I do.
No, you don't care.
I do.
You don't care that my day has now come to a screeching halt.
I know. I do, actually.
And it's usually Miss Akinroli that the case does that. But
today,
now you're following in her footsteps.
I know. Your Honor, I was going to request an adjourn. Oh, and he's there. I was going to.
I had faith that he'd appear.
Thank you, Your Honor. I did too, even though my voice didn't show it.
Mr. Duncan, can you state your name, please?
Dustin Duncan.
Thank you.
Your Honor, I am, this is the first PCC. I'm requesting a brief adjournment. Mr. Duncan, I'll follow up with you. I talked with the prosecutor this morning about your options, so I'll follow up with you about what you want the next step to be in your case, okay?
Okay.
All right. So what I'll do is I'll adjourn this to August 28th, 2025. 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, Mr. Duncan.
Thank you, Your Honor.
Court does call the case of the People versus Jeffrey Williams. All this.
Matthew Nasser, Assistant Public Defender, with and on behalf of Mr. Jeffrey Williams. Jeffrey, can you please state your name for the judge?
Jeffrey Williams. Thank you, sir. Sir. You're requesting an adjournment.
Yes, please, Your Honor.
Can I just buy it, officer? Can we just buy the elevator to a dating store? Cause I don't want to be wasting time just sitting here.
Okay.
And I know.
I'm
sorry, Your Honor.
I'm sorry, I didn't want to interrupt the conversation, but is he any closer to getting to treatment? Or I'll sign the stipulation.
Okay.
I'm currently waiting to get to the assessment for drug treatment court, and that's the first thing they're going to do for me before the drug treatment court is serious treatment.
Okay, all right. And I would just say that Mr. Williams has been appearing before me for some period of time over the years. He needs treatment.
Yes, Your Honor. Yes.
He actually has been through treatment, and I'll say this on his behalf. When he kind of gets through it and he's up, he's good. Just when he slips back into that bad world, then things start going haywire for you, right?
Yes, sir.
We're hopeful history doesn't repeat itself. We can move forward and
Yeah, well, I hope so too. So this is 14B. Do we have a time frame as to how they're?
Your Honor, I made a request to council that since I think Mr. Williams does not yet have an inpatient bed, waiting for him that he contacts, and I can as well contact Mr. Reyes and ask you to interview in the jail ASAP before he even goes out to a bed so that it can be done quickly.
thank you.
So let's do this. I just, August 28th, 2025, 9 a.m. I just don't want to put it out too far.
Thank you.
Track of it. So we'll go out to that date. And then let's see where we can get. All right.
Thank you, Your Honor.
All right, Mr. Williams, take care. Court does call the case People versus Thomas Ellis.
And Assistant Public Defender, Chanel Carrier, Your Honor, on behalf of Mr. Thomas Ellis, Mr. Ellis, state your name for the record.
Thomas Ellis.
Judge, I do have a green sheet. We're requesting an adjournment in this matter. There's some information that I just provided to the people today, so I think 2 weeks should be fine, Your Honor.
How long?
2 weeks, I think, should be fine.
Just come back and ask for more drink. That's how you are.
I know. I'm
All right.
sorry, Judge. I'll do better.
Oh, no, you won't. August 28th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
You're gonna promise me I'll do better, but I know that, Benny. Gotcha. Court does call the case People versus Keon Ford.
Court, when you are present, please state your name for the court.
Keon Ford, thank you, sir.
And we are asking for an adjournment of this matter, Your Honor. I've been in touch with the prosecutor regarding my questions and concerns, and he's going to work with me to hopefully get it resolved.
Try to.
Yes.
All right, let's set you out to September 4th. 2025, 9 a.m. Bond continued.
Thank you.
All right.
Thank you. I'll call you like I did before. Thank you so much, Your Honor.
Court does call the case People versus Marcus Jones.
For the judge, Andrew Childers, appearing on behalf of you. Judge Fleischer, Assistant Public Defender on behalf of Mr. Marcus Jones. Mr. Jones, please state your name for the record.
Marcus Jones.
Thank you, Judge. I did have a chance to talk to Mr. Jones and Mr. Childers about this briefly. Mr. Jones had a few more questions about the plea offer in this file. If we could go out just a week or two, I think we have a resolution.
Probable cause conference, then August 28th, 2025, 9 a.m.
Can I say something?
Can you say something? Sure.
Y'all need a cell phone. Do y'all have a cell phone? Because I was just calling and calling and calling this morning because I knew I was going to be late. But like trying to get in touch with y'all was like trying to get in touch with somebody that don't want to be found by their mama.
Just call me.
Like,
who are you telling? I need a cell phone?
Somebody need a phone.
3.
Somebody need a phone.
I just don't give you the number.
But then, man, dog, I thought I
see, you're like that child mama don't want to find.
Man, bro, I had to turn into a track star this morning. You ever seen Peter Parker when he was running for the bus? Yeah, man. Yeah.
That was you this morning?
That was me this morning, bro, with the bag in my hand and everything.
Yeah, was that down Washington?
Huh?
Were you coming down Washington at some point?
That was me.
That was you?
That was me.
Oh.
That was me.
You were going fast.
Yep.
I'll give you my number, okay?
All
All
right.
right, so here's what I think. I am not giving you my cell phone number.
Hey,
I'm just letting you know.
You a judge. I will want it.
Yeah, you're right.
I'm
Wanna
just
call
there.
me.
I defend myself.
So I think, let's see, who will answer? Give it, Mansoor, give him your number.
Yeah. Good idea. Good idea.
I'm sure Mr. Fleischer will find a number for you.
I will.
Okay?
Yeah.
But I'm just so happy you got here.
Hopefully it ain't 773-9311.
What's that?
Oh, hey, she got it. Said I'm messing with you, bro.
Okay. That's beautiful that you and Cannon shared that moment.
I didn't get it.
I didn't either.
Yeah.
There's no telling.
All right, you have a nice day.
Okay, you do the same. Take care.
Thank you, Judge.
Man, you weren't even giving up your phone number. What? Well, I'm gonna let the powers that be know he wouldn't cover his client. Just time was just looking for somebody to call. I'm just gonna say. You know, when he said, "Can I say so?" I was just hoping I thought it would be just something. Didn't know it was gonna be all that. Court calls the case People versus Zion Jones.
Good afternoon, everyone.
Ready, Judge Torshio Fleischer, Assistant Public Defender on behalf of Mr. Zion Jones, who is not present, but I know where he is. If I may.
Hey, you want to share that with the rest of us?
Yes, Judge. I got a text message from our office this morning.
If he's on a bus, I don't want to hear.
Not on a bus.
All right.
So apparently he bonded out of jail yesterday, went to work. He works on the line and he injured his leg. He's at St. Joe's Hospital. So we asked him to get proof of his hospital visit, and we're asking for a brief adjournment so he can come next week or the week after, whenever the court's pleasure is. But he's at the hospital.
So he got out of jail, went to work, hurt his leg, and now at the hospital.
Yes, Judge.
Ms. Zender, why'd you wave your head like? Wow.
And I called him to verify. He answered. I said, "I'm at the hospital. I'm getting a letter. I'll bring it when I leave." So.
Can I do a request of 48-hour bench for the defense failure to appear? I would just like to.
Why would we do that?
To give him time.
He has a whole story.
I will take Mr. Fleischer at his word. I trust.
Okay, then.
I would also just represent, similar to the co-defendant, I am preparing an amended complaint with the added count of assault with intent to commit robbery while armed.
This was the one that you're trying to up the bond on, and.
That is correct, Your Honor.
Fleischer?
So Judge, I would ask that the court not up his bond until that is actually filed.
I'm not gonna up his bond at this time, because I need the amended complaint. I don't have that. But.
And I will forward the court and the cook the hospital letter as soon as I receive it this afternoon, Your Honor.
August 14th, I'm good, 1 week.
Thank you, Judge.
I'll adjourn it out based on that story you gave me.
Thank you so much. And I will get the proof.
And if he doesn't show up,
I understand.
I'm gonna issue a bench warrant and take you in.
No, I don't understand that.
No, that's the way it works. You want me to go with the story, that's how it's
You
gonna
know
work.
what? You can issue the bench warrant today then, Judge. I don't want my freedom tied to his. Thank you, Judge.
You're welcome. Court calls the case People versus Olin Thurman.
Haley Zenda on behalf of the people, Your Honor.
Assistant Public Defender Alexis Zerpswith on behalf of Mr. Thurman, who's approaching. Can you please state your name for the record?
Olin Thurman.
Your Honor, can we briefly approach?
Fine.
Recording is done.